Morning, everyone. Happy that everyone has joined us today for this meeting, the Committee of Bar Examiners here on Friday, October 15th. Ms. Wong, would you please take roll?
Yes. James Bolton.
Here.
Robert Brody.
Here.
Michael Cow.
Here.
Alex Chen. James Efting.
Here.
Karim Gongora. Dolores Heisinger.
Here.
Judge Herman. Michael Iseri.
Here.
Rick Kaplan. Paul Kramer.
Here.
Bethany Pick.
Then
Vince Reyes.
Here.
This is Larry Kaplan. I'm here.
Thank you, Mr. Kaplan. Judge Shelley Toriaba. David Torres.
Here.
We have a quorum, Mr. Chair.
I'm present too. This is Karim Gongora. Good morning, everyone.
Good morning, Mr. Gongora.
Thank you, Ms. Wong. We have a very full agenda today. And we're going to be, because of the availability of some of our presenters in the agenda, we will be going out of order, but we will definitely let everybody know and how to stay updated as we go from open to close and back into open. But again, as noted on the agenda for today's meeting, public comments during the meeting will be limited. Members of the public wishing to comment were encouraged to submit written comments prior to the meeting to ensure that the committee would have time to consider those comments. Now, the committee has received and read all the written public comments. We thank you for that. Ms. Wong will attempt to call members of the public in the order they appear. Due to the number of people requesting to make public comments, we ask that you limit your comments to 2 minutes. To facilitate hearing as many members of the public as possible, I encourage you not to repeat points that were made by previous speakers and to allow the committee the time needed to deliberate on the important topics that we'll be discussing today. We will not be able to hear more than a maximum of 15 minutes of total public comments. For those of you who are participating via Zoom video, you should have a function for virtually raising your hand. It's a hand icon and should appear at the bottom of your screen. If you wish to make a public comment, please click on that. For those of you who are participating by phone, you may virtually raise your hand by pressing *9. That's the star key, then the number 9. Ms. Wong will call members of the public in the order that they identify raised hands and will enable the microphones of those speakers. With that being said, Ms. Wong, do we have anyone wishing to make public comment?
Yes, Mr. Chair. At the moment, we're going to start calling Freddie Alikani. Go ahead, Mr. Freddie Alikani.
All right. Good morning, everyone. Can you all hear me?
Yes, we can.
Okay. I'd like to raise the issue that I had, and I thank you for the opportunity given to me. I was one of the individual examiners with the accommodation. So I was diagnosed with ADHD and I was given double time. My problem was not having a black screen or having a memory issue with the computer. The password that was given to me was not working. So I logged in 5 minutes right after it was given to me at 4:35. I was supposed to take on the first day, the fourth question. And unfortunately, the password did not work. I called ExamSoft. Finally, we ended up working it at 7:03 p.m. So I ended up finishing up the exam at 9 p.m. on a different computer, removed the software. So we went from the high-tech laptop to a bare minimum laptop, uploading a question on a different one. So 3 hours of stress entirely for somebody with a distractibility issue. It was the most difficult task that I have ever experienced pretty much in my life. And it was not raised in any of the issues from ExamSoft. So I just wanted to provide that. I also provided a written in general application inquiry on the portal as well. And thank you.
Thank you. The next public comment is from Victoria Tulsidas. Ms. Tulsidas.
Good morning. How are you?
Good, thank you.
Yes, I just wanted to just lend my experience that I had during the third question on the exam. As I was just writing my essay, I experienced a blank screen. I was taking the exam in a hotel, and I tried to restart the computer over and over again. So I immediately thought that it was an internet issues. I went crazy. I called one of the people in the hotel, and I'm like, your internet is down. Their tech person came, and he's like, they started trying to help me start my computer. And then they confirmed that it was not their internet. It was no Wi-Fi issue. So I frantically began to take pictures of everything. I then called the state bar, and I was on hold for, I mean, it felt like an eternity, probably about 30 minutes. I was on 2 phones. I was on my personal cell phone, as well as the hotel's front desk phone. Then I called ExamSoft, and it took me about 25 minutes to get through to ExamSoft. By the time that ExamSoft could help me rectify the issue, it timed me out of the entire essay. It was the third essay of the day. I didn't eat my lunch for the next exam, and it was just a nightmare. And I'm sorry, my children are in the background. Having prepared for so long to take the exam and all of the expenses and resources used, I felt like my whole world crashed in on me that day. I went literally almost mad. My husband had to talk me into completing the exam because I just wanted to give up. I thought my whole life was over. It was devastating. So I just wanted to share that because it was a real experience.
Thank you, Ms. Tulsilda. The next public comment is from Benjamin Cohn. Mr. Cohn, go ahead.
Yes, hello, thank you. I wanted to address the issue with the NCBE requiring that the state bar not entertain testing accommodation requests of remote testing. I feel that that is extremely reckless, given that immunocompromised people will still have inadequate protection from a private room. They have to travel to get to the test center, which has inevitable exposures for the transit, the lodging, and the meals to take the test. And the proctors under the current policy are not required to test negative or be vaccinated unless the test site is 1,000 people or more. There's not really a good reason for that. There also seems to be, from public records requests, no policy for contact tracing and policy of not notifying examinees if their proctor was found out during the exam or before the exam to have been exposed to COVID. That with this policy that immunocompromised people have to test in person seems to be a real health and safety hazard. So I would urge you to, if the NCBE is not allowing that to happen, to either drop them and do your own multiple choice test with the psychometrician, or ask the California Supreme Court for an order that would allow the NCBE to, under their policy, to provide the test remotely. Besides that, I would encourage more transparency in responding to public records requests about these issues. I am not satisfied with the response that I was given to mine. Thank you.
Thank you, Mr. Cohn. Mr. Chair, at the moment, we don't have any more public comment.
Thank you, Ms. Wong. And on behalf of the committee, I want to thank the public who did share their comments, and again, who did also submit written comments. Moving on to Open Agenda 100, you have the 2021-22 committee year subcommittee assignments available to you. I want to thank all of those who have served in the past in different leadership positions with the subcommittees. There are some new appointments as chairs and vice chairs of various committees. So, and as in the past, what we've always tried to do is give people different experiences and exposures to the committee. So appreciate your efforts in the past. And as we go forward, of course, as you see on the agenda, we'll also be reviewing goals within the different subcommittees as well. And then with open session 101.
Mr. Chair, sorry to interrupt. We need a motion to receive and file the assignment.
I'm sorry. Yes, is there a motion to?
So moved. This is Kareem to accept and file.
Is there a
Second.
Thank you, Dolores, thank you.
Thank you. Let me roll call. Dr. Bolton,
Yes.
Judge Brody,
Yes.
Dr. Kao,
Yes.
Mr. Chen,
Yes.
Mr. Efting,
Yes.
Mr. Gongora,
Yes.
Ms. Heisinger,
Yes.
Judge Herman, Mr. Iseri,
Yes.
Mr. Kaplan,
Yes.
Mr. Kramer,
Yes.
Ms. Peak,
Yes.
Mr. Rios,
Yes.
Judge Toriyaba, Mr. Torres, Mr. Torres. The motion passes.
Thank you, Ms. Wong. And then now we have the 2021-22 Law School Council and Committee of Bar, a Committee of State Bar Accredited and Registered Schools officers and members. Again, you have that list available to you. We have 4 newly appointed people who are joining that committee as well. So again, looking forward to a lot of the great work, continuing a lot of the great work that those 2 committees have done in the past for that. Don't believe we do need a motion on that. We do not need a motion on that. And with that, I believe, Amy, are we ready for the orientation for committee members?
Yes, we are. Either Kim or I believe Devin, you have our PowerPoint.
Yes, one moment.
Okay, thank you. So every October, we present an orientation about the functions of the Office of Admissions and are available to answer any questions as we're going through. We provide it to all of the committee members because we incorporate any changes, any policy that has changed from one year to the next. So that is what's being incorporated here. So with that, I'm going to hand it over to Audrey, who will commence this presentation.
Good morning, Committee of Bar Examiners. Welcome to your orientation. Next slide, please. So we're going to go over a high-level overview, conflict of interest policy, legal authority governing the CBE, exam development, exam grading, legal authority governing testing accommodations, our operations and management procedures, moral character, and then end with law school regulation. Next slide, please. So I'll take you through sort of a high-level overview. Next slide. So these are the entities overseeing the work of the Office of Admissions. You see where the Committee of Bar Examiners is on this slide, the Board of Trustees, the Supreme Court, and the Legislature. Next slide. This is our most up-to-date organizational chart here at the State Bar of California. You can see where admissions is. We're in the programs division under our Chief of Programs, Donna Hershkowitz. You can see the admissions area there with Amy's name. Next slide, please. And here is the drill down org chart for the Office of Admissions. Amy, the director, overseeing the entire office. And then I oversee directly operations and management, law school regulation, and our legal specialization area. Amy works directly with exams, grading, testing accommodations, moral character, and our wonderful administrative support from Kim and Devin who are currently helping us with the slideshow. Next slide. The Committee of Bar Examiners consists of 19 members, 10 who are lawyers appointed by the Supreme Court, and 9 public members serving 4-year terms. We have 4 subcommittees that we talked about already this morning: educational standards, examinations, operations and management, and moral character. We have 2 law school committees: the Committee of State Bar Accredited and Registered Schools, which we call CS Bars, and our Law School Council. Next slide. Well, this year we have some exciting ad hoc assignments in process: the Blue Ribbon Commission, which is looking at the future of the bar exam, and Differential Item Functioning, or DIF, working group, which you will hear some updates on those today as well. And I will hand it off to Brady. Thank you, Brady, for coming to the CBE meeting today.
My pleasure. Let's go to the next slide to start. So my name is Brady Dewar. I am an attorney at the State Bar with the State Bar's Office of General Counsel. And I'm one of the attorneys in my office who advises the bar, its leadership, and its employees and its volunteers, like CBE members, on conflict of interest concerns. And during this brief training, we will go over some of the very specific policies and laws that apply to the CBE. But before that, and you know, if you guys take anything away from this brief presentation, at a very high level, we just want you to think about, you know, as you approach your work for the CBE, whether you have any potential personal or financial interests in any of CBE's work. And that could be, you know, a personal relationship or a familial relationship, whether a close friendship or, you know, the child of a very close friend who is going to be taking the exam during your term on the CBE, whether you have any business or personal relationships with potential vendors who might be involved in putting on the bar exam, whether you might know or have personal knowledge of somebody whose moral character determination comes before the committee. Any of these sort of connections that you might have to any of the work, you know, as close or attenuated as they might seem, we want you to think of those. And if you identify a potential connection, just let somebody know, whether it's Amy, one of the coordinators of the CBE, or the CBE chair, and then they can work as appropriate with my office to decide whether there really is a conflict and what the proper method for addressing that conflict is. Because ultimately, we want to avoid conflicts, both to comply with all of these policies, but also to maintain actual and perceived faith in the legitimacy and the honesty of our process, because that's very important. So that's sort of the high level takeaway I want, and now we'll get into some of the details. If you want to do research on your own, here are the sources of our various conflict of interest policies and rules applicable to the CBE. First of all, there's the CBE conflict of interest guidelines. Those are adopted by the CBE itself and speak specifically to some of the work that you do. Second, there's the conflict of interest code for designated employees of the State Bar of California. Despite its title, although you are volunteers, CBE members, along with members of some of our other boards and committees, are designated employees under that, which means, for instance, that you file a Form 700 when you start and leave the committee, and every year thereon. Additionally, rules of procedure of the State Bar, Rule 3101, speaks to conflicts for CBE members. Business and Professions Code, sections 6036 through 6038. That is the provision of the State Bar Act, which requires recusal where members of the Board of Trustees and designated employees of the State Bar of California, such as yourself, it requires recusal if you have a personal interest or a financial interest in any decision of the CBE. And finally, there are portions of the Political Reform Act of 1974, which are adopted by those other policies and statutes statutes, essentially, which define what a financial interest is and what sort of financial interest leads to disclosure. So this is the body of laws and policies that we look at in dealing with conflicts of interest issues. Violations can carry serious penalties, and part of the reason that we're so vigilant and encourage you to bring literally any concern you have to us is that if there's ever a willful violation, there can be pretty serious consequences, including personal fines, removal from the committee, disqualification from holding public office, and even criminal sanctions for the very most intentional and egregious violations. Sorry, I'm clicking myself. Next slide, please. Thank you. So it looks like I already covered some of this in my own statements. As I mentioned, the Committee of Bar Examiners Conflict of Interest Guidelines were adopted by the CBE. They set forth procedures for determining if recusal from matters before the CBE is necessary, and it restricts also certain activities of former CBE members. We'll get into that. The Conflict of Interest Code I mentioned for designated employees of the State Bar of California is adopted annually by the Board of Trustees. There will be a 2022 version adopted next month, and that covers enumerated sub-entity members, including CBE members. Next slide, please. So under the general procedure for identifying potential conflicts is that CBE members shall immediately disclose the following types of potential conflicts to the CBE chair and Amy Nunez, the program director of admissions. If you have a significant family, professional, business, social, political, or other relationship, adversarial or allied, direct or indirect, with an applicant or petitioner. So if you know somebody is applying for admission to the bar, or you become aware of that at any point in the process, that you know at all, basically, it's pretty broad, you need to bring that information forward so that we can evaluate it. Additionally, any type of current or past relationship with a law school or bar review course other than as a graduate, we need to know about. So whether you have an employment relationship, a volunteer relationship, whether you're on the board of a law school or bar review course, we need to know that if we don't already. Next slide, please. So under the policy, the conflicts policy for the CBE, after a disclosure to Amy Nunez and the chair, if disclosure is required, and we will advise you of that, you will then be required to disqualify yourself from any decision that affects the person or the entity that you have an interest in. The way that would happen in practice at a meeting is that you would disclose the interest. I have a relationship with an applicant. You would say, I'm withdrawing from participation in the matter, and you would then refrain from discussing, voting, or doing any work on that matter. You don't need to go into detail at a public meeting about what your relationship is. It's sufficient for the purposes of disclosure to say, hey, I have an interest in this decision, and therefore I am going to recuse myself. Next slide. So we have a little bit more detail on disqualification and recusal relating to a specific applicant under the CBE conflict of interest guidelines. Generally, the approach we take under this guidelines is that we look for consensus. So, you consult with the chair and program director, with Amy and the chair of the CBE. And if there's a consensus that a past or present association between a CBE member and an applicant or petitioner, there's a consensus that could unduly influence you as a committee member, or more importantly, and this comes up most often because often people think that they can be impartial, but the question is whether there could be a perceived conflict of interest, whether from the outside looking at it, we might think, that draws the impartiality into question. If there's a consensus of that, the member must recuse himself, as we mentioned, from all activities that may be associated with the processing of an application or petition before the CBE. So you would need to leave the meeting room if a related issue is being discussed, refrain from attempting to influence other members' decisions regarding that particular applicant. Next slide. And if the issue involved your relationship with a particular applicant sitting for the bar exam, you would need to recuse yourself from all activities specifically related to that bar exam. So development of questions, administration of the test, and grading of the examination. If you had a close relationship with somebody in the examination, we would ask you to recuse yourself from those activities. Just a note, a committee member who has been disqualified from any of these activities is not precluded from providing information concerning an applicant in the form of information in a confidential questionnaire. So if you get a moral character confidential questionnaire, you can still respond to that. Next slide, please. There are also some rules regarding contact with law schools. So while you are serving on the committee, you must refrain from personal contact with the law school regulated by the committee, including accepting meals that are paid for by the school. Exception is for meals that are scheduled in conjunction with a regular visitation to the school, or a noticed meeting of a group of law school representatives, or when you're making a presentation to the school on the committee's activities. This is an area where there's distinctions and sometimes gray areas. So, you know, if you are having interactions with a law school regulated by the committee, just let us know and we'll help you navigate that. Next slide. There are also some prohibitions on representation before and involving the State Bar and the CBE. During your term of office, you shall not represent a party in a matter which involves the regulatory jurisdiction of the State Bar and in which the party's interests are adverse or conflict with State Bar's regulatory interests. So, you know, while you're on the CBE, you should not be defending a respondent attorney in State Bar Court, for instance. For 6 months following the end of your term, you shall not represent a party in a matter which involves the State Bar's regulatory jurisdiction and in which you had supervisory responsibility. So for instance, if there was litigation involving activities under CBE's jurisdiction, you would not be allowed to represent a party in such litigation for at least 6 months following the end of your term. And thereafter, and this has no time limit, you may not represent a party in a matter which involves the State Bar's regulatory jurisdiction and in which you personally and materially participated during the State Bar service, during your State Bar service, or for which you, or where the matter involves confidential information to which you had access. And this, in addition to violating CBE rules, if you were an attorney, might violate some professional rules also. So I think when you think about it, it's probably common sense. But again, Amy and our office, if there's any questions here, are open to you. But you know, the area where there could be some issues is if you, after leaving office, are somehow appearing before the bar or in litigation involving the bar. Next slide. Last restriction. For 12 months following the expiration of your term, you must not seek to perform any business with the CBE for monetary gain. So you know, don't do work with us or for us for money, or act as an agent, attorney, or representative for compensation by making any appearance before the CBE, a State Bar employee, or the State Bar Court for the purpose of influencing official CBE or State Bar action. So no lobbying or advocating for compensation before the State Bar for 12 months. Next slide. This next set of slides discuss the provisions of the conflict of interest code for designated employees. As mentioned, CBE members are deemed designated employees by the policy adopted annually by the Board of Trustees. This code disqualifies CBE members and others designated from participating in decisions that have a reasonably foreseeable material financial effect on you as a CBE member or a member of your immediate family or your financial interests, such as your investments or income sources. The code also requires you to file statements of economic interests, typically known as Form 700s. And on those, you disclose only those financial interests that result in disqualification under the code. So it's a little bit of a circular reasoning, but you're not going to have to disclose a lot. Generally on your Form 700, often you won't have to disclose anything. Really what you need to disclose is if something came up in the past year where you had to recuse yourself because of a financial interest, then you will disclose that financial interest on the next Form 700. So just as for instance, since this covers members of your immediate family, if you had a spouse who was taking the bar exam, you would have a financial interest in the outcome of their petition for admission to the bar, because that would affect their income and therefore your income. So for that reason, in addition to it being a personal interest, you would have a financial interest in whether your spouse passed the bar exam. So you would need to recuse yourself from decisions involving that administration of the bar exam. Once you've done that recusal, because of that financial interest, the next time you file the Form 700, you would note that interest on the Form 700. And again, we can help you with that. The code also prohibits CBE members from accepting honorariums or certain gifts from sources upon which CBE decisions would have a reasonably foreseeable material financial effect. And we will get a little bit into that more, I believe, on the next slide. Next slide, please. Oh, got ahead of myself. So we talked a bit about financial interests, which require recusal and if that occurs, disclosure on your Form 700. So here's a bit more about what constitutes a financial interest. So again, the rule is that a CBE member must not make, participate in making, or attempt to influence any CBE decision that the member knows or has reason to know will have a reasonably foreseeable material financial effect, distinguishable from its effect on the public generally, on the member or his immediate family. So if it'll affect your income or the income of your immediate family, or if it'll have a financial effect on a business entity or real property in which you have an investment or an interest worth $2,000 or more. So if, for instance, you had an investment in a company that provided software services for the bar exam, you would need to, if your investment was worth $2,000 or more, you would need to recuse yourself from any decision regarding the state bar's potential use of that vendor. Financial interest also, it is also a financial interest. You also have a financial interest in any source of income, including gifts that aggregated more than $500 over the previous 12 months. So if you are a consultant or a practicing attorney and you have a client who has paid you more than $500 over the previous 12 months, then anything that has a financial effect on them constitutes a financial interest for you. So again, if you represent, I'll use the same example, a vendor of exam services, then you have a financial interest in that vendor, and you would need to recuse yourself from any decisions affecting that vendor. And finally, you also have a financial interest in any business entity in which you are a director, officer, partner, we've said twice, trustee, employee, or manager. Next slide, please. Back to honorariums and gifts. So a CBE member may not accept an honorarium, just a gift or a fee for speaking, if the member would be required to disclose it on his or her Form 700 statement. That means if you knew or had a reason to know that a decision before the CBE would have a reasonably foreseeable material financial effect on the source of the honorarium. So again, this is basically you can't accept speaking fees from a party or an individual who is going to have, or who has business or could be affected by a CBE decision. So again, software vendors, applicants to the bar can't accept honorariums from them because if you did, you would have to report that interest. Again, it's a little circular, so the easiest way to explain it is this honorarium bar applies to anybody who has any source of the honorarium who has who might be materially impacted by a decision by the CBE. I think is the easiest way to say that. You may also not accept gift or gifts valued at more than $500. Again, if you would be required to disclose that gift on the Form 700 statement. So no gifts of $500 or more from an applicant to the bar, from a vendor or anybody involved in the testing moral character process at all. The exceptions to that are gifts from close relatives. So if you have a child or a sibling who is taking the bar, you would, have to recuse yourself from decisions affecting that bar, but this gift ban wouldn't apply to you because you have that pre-existing personal relationship. Next slide. So Form 700 reporting, we touched on a bit. The Form 700 must be filled out upon assuming office. Annually thereafter, they'll be due by April 1st and again upon leaving office. So if you are new, you should have received or soon will receive forms and instructions from State Bar staff. When you are new, by definition, you will have nothing to report because again, it looks back. When you file the form, it looks back over the past year and asks, did you have any financial interests that led you to recuse yourself from a CBE decision? Obviously, when you're new, that's not possible. You haven't made any CBE decisions to recuse yourself from yet. Second bullet, same point. You need only report a financial interest, which again includes investments, real estate, income sources, etc. if during the reporting period, that financial interest was grounds for you disqualifying yourself from a CBE decision. And again, not only in their entering office, assuming office reports, but often in their annual reports, CBE members simply fill out the form saying that they have nothing to report. Next slide. These Form 700s, important to note, are subject to public information requests. I don't know that we get them very often, but they are publicly available documents. So for that reason, you may choose to use the State Bar's contact information or your business contact information if you'd rather your personal contact information not be disclosable in that manner. Next slide. There's a separate provision of the government code that deals with contracts and conflicts involving contracts. It's Government Code Section 1090, and essentially covered individuals, which is members of state bars and bodies such as the Board of Trustees, the CBE, shall not be financially interested in any contract made by them in their official capacity or by any board body of which they are members. One conflict can disqualify the entire board, and the effect of this, and it comes up more often with the Board of Trustees, since generally they're overseeing the contracts, but some of these contract conflicts issues can't be solved through recusal. So the point we want to make here is that if you are aware of any interest or any association at all that you have with any vendor or consultant or anybody that the State Bar may be doing business with for tasks related to the CBE's work, we need to know about that as soon as possible, just so that we can sort of navigate this body of law and make sure that that relationship or conflict doesn't affect the State Bar's ability to do business or to enter a contract with whichever vendor or consultant is at issue. Next slide, please. That's it. So I know that was pretty dense. We'd be happy to, if you have, actually, I'm happy to take any questions now, but I did want to just repeat that, the basic gist I want you guys to get is that there are a lot of rules, but really easiest way to stay in compliance is to sort of think broadly, whether you have any personal or financial interests in anybody taking the bar exam, anybody with particular issues coming before the CBE, or anybody involved in the business of putting on the bar exam and doing the CBE's work. Let us know that as soon as possible. We'll get the relevant information from you and help you decide how to go forward from there to avoid any issues. And that will help the committee do its work, and it'll help maintain the public confidence in the process. So with that, I will open it to any questions, and I'm always available. I didn't put my email up there, but it's brady.doer@calbar.ca.gov, or you can ask Amy or anybody on staff, and they'll forward questions to me. But I'll open it up now. All right, I don't see any. I'm not the best Zoom MC, but I don't see anybody, so I think that's it.
I don't see any hands either, Brady, but thank you so much for all of this information.
No problem. Thanks a lot. Have a great day.
All right, you too. Okay, so I'll be covering the legal authorities that govern the CBE. This is a section normally done by Caroline, but I will be covering it today. And essentially, I'll be highlighting California Rules of Court, Business and Profession Code sections, as well as State Bar rules to highlight some of which you've already heard in terms of what the legal authorities are that govern the CBE. Next slide, please. So here you have heard some of this already. The Supreme Court of California has the inherent power to admit persons to practice law in California. The State Bar is the administrative arm of the court for admission matters and acts under the authority and direction of the court. The CBE, acting under the authority delegated to it by the Board of Trustees, is authorized to administer the requirements for admission, to examine applicants for admission, and to certify to the court for admission applicants who fulfill the admissions requirements. The one thing I wanted to mention here is that there are rules of court and business profession code that reflect this. These will be incorporated in a CBE manual that we'll be sharing with each of you next week. So you will get some of this in writing as well. Next slide, please. This is a highlight of the composition of the, the composition of the CBE. You got to see this in Audrey's presentation of what the 10 members, 10 attorney members appointed to the CBE. One must be a judicial officer, and the rest must be a California licensed attorney that have been admitted to practice, and at least one has to have been admitted to practice within 3 years of their appointment. The court may reappoint a member to serve no more than 3 additional full terms and may fill any vacancy. And the court makes its appointment from a list of candidates nominated by the Board of Trustees. And this is pursuant to a rule approved by the court. Next slide, please. So rules that are adopted by the CBE are, problems with too many PowerPoints open. I'll just stick to one. So all state, do you guys hear? Okay. All State Bar rules adopted by the Committee of Bar Examiners pertaining to admissions to practice law must be approved by the Board of Trustees, and then will be submitted to the Supreme Court for its review and approval. Next slide. Now, there are various business and profession code that govern the legislative authority over the State Bar, admissions, and the CBE. Again, these will be included in the manual, but here you see that California Supreme Court here has respected the exercise by the legislature under the police power of a reasonable degree a regulation of the legal profession and practice of law in this state. The legislature created the State Bar, a public corporation, with the enactment of the State Bar Act of 1927. Next slide. B&P codes 6066 and 6046.5 require, again, at the CBE have 9 public members who have never been licensed with the State Bar or admitted to practice before any court in the U.S. Each of those members serve 4-year terms, and these are the appointing authorities. So Senate Rules Committee, Speaker of the Assembly, and anybody appointed and appointed also by the governor. The public members have the same rights, powers, and privileges as any attorney member, except such that a member shall not participate in the drafting of questions submitted to applicants on the California bar examination. Next slide, please. The State Bar is governed by the Board of Trustees, which is charged with the executive function of the State Bar and the enforcement of the State Bar Act. The board is empowered to formulate and declare rules and regulations necessary or expedient to carry out the act. So they have the power, the board may establish a CBE having the power to 1, examine all applicants for admission, 2, to administer the requirements for admission, and 3, to certify the court for admission applicants meeting all admission requirements. Next slide. So subject to the approval of the board, the CBE may adopt such reasonable rules and regulations as may be necessary or advisable for the purpose of making effective the qualifications for admissions. On November 4th, 1981, the board passed a resolution declaring that the CBE must comply with all Board of Trustees policies, including but not limited to contract, fiscal, and grant policies and personnel-related policies. Next slide, please. All state bar committees only have the powers, duties, and authority delegated to them by the board and are subject to its supervision and control. The board reserves authority over all matters pertaining to the state bar. Unless expressly authorized by the Board of Trustees and the rules of the state bar, a committee must not act or speak or purport to act or speak for the state bar, make any public communication on behalf of the state bar, or poll or put a vote of all or a substantial number of licensees any matter on which a bar has acted or is empowered to act. Again, these are state bar rules that will be included in the manual as well. Next slide. All right, we are going to move on now to exam development and grading. But before we do that, are there any questions about the legal authorities over the CBE?
I have a question.
Oh, go ahead.
Sorry, Chair, go ahead.
No, go ahead, Mr. Gongora.
I just had a question about the drafting. I remember that being highlighted, but is the selection also an issue as well? Or is it just like the development phase? Or is that inclusive?
Yes, so question selection is part of that drafting, because at that point, I don't know if you recall, the selection involves some drafting at that session. So in the event that there are some issues, there have been edits that happen at that session.
So you can't participate or you can't select?
Non-attorney members are not invited to that session because one may lead to the other. So you could select a question, have questions about it, and it leads to the drafting portion or editing portion.
Thank you.
Sure. Alex, did you have a question?
Quick question.
Oh, yes.
As you were reviewing the composition of the committee, it occurred to me, I don't think we have any new members this year. Is that right?
Our newest member is Dr. Wilcoxon. And yes, so we don't.
Okay.
Mm-hmm.
Thank you.
Sure. Alex, did you have a question?
Yes, so my turn. So just you mentioned earlier about materials being sent. Those will be sent in the mail to all the committee members. Is that correct?
That's correct. And so the manual will have a description very similar to what we're discussing today and highlighting here, as well as an appendix that includes many of these rules, as well as, for example, some of the more recent considerations that we've had, such as the Chapter 6 matrix, our updates to the moral character review process, some of the material that resulted from the moral character working group. So it's a binder that we're hoping it will serve as a really good reference tool to the the Committee of Bar Examiners.
Great, thank you very much.
All right, then I'm turning this over to Lisa.
Hey, thank you, Amy. Good morning, everyone. I will be covering under my portion development, both of the California Bar Examination and the first-year law students examination, as well as I will be covering Christina's portion on examination grading. Next slide, please. So the California Bar Examination, as of the July 2017 exam, is a 2-day exam. Prior to that, we had 3-day exam. Day 1 is comprised of 5 one-hour essay questions and 1 90-minute performance test. So during the pandemic, we did administer an online remote proctored bar exam. And during that, those administrations, the written portion of the exam, the questions were each administered separately in separately timed sessions. But for the traditional bar exam, which we will be going back to for the February 2022 administration, we have questions that are administered in sessions, so multiple questions in one session. Day 2 is the 200 multiple choice item multi-state bar examination, the MBE. That exam is proprietary to the National Conference of Bar Examiners, the NCBE. So what it is it's administered in 2 sessions on day 2, 100 questions in the morning and 100 questions in the afternoon. With the online remote exam, we did have 4 sessions, 50 questions each that were administered separately. Next slide, please. So the scope of the California Bar Examination covers 13 subjects, and they're listed for you on the slide you're seeing. I do want to point out that for the civil procedure and evidence topics or subjects on the bar examination, we do cover applicants are expected to know that both the federal and the California rules. And then for the professional responsibility subject, we expect the applicants to know both ABA and California rules. Next slide, please. So the development of the California Bar Examination questions, that would be the essay questions and the performance test. Generally what happens is there's initial drafting. The questions are solicited from law professors and other qualified drafters throughout the United States. PT drafting is done by a dedicated team of independent contract PT drafting experts. So after the items are drafted, we do editing. And then after editing, there is pre-testing that goes on for both the essay questions and the performance tests. And further editing of the questions and the PT are done in being informed by the pre-testing results. And then the essay questions and the performance tests are banked so that they can be selected in the future for administration on an exam. Next slide, please. So this is now an overview of the first-year law students examination, which is affectionately known as the baby bar. It is developed a little bit differently. We have, as well as it's a different exam. So it's a 1-day exam rather than a 2-day exam. We have a morning session during which 4 one-hour essays questions are administered. The format of the online remote exam is that all of the essay questions are administered separately timed sessions. Traditionally, they would be all administered at one time in a morning session. The PM session, the afternoon session, is 100 during which 100 multiple choice items are administered. That exam is proprietary to the State Bar of California. We develop and we own it. And the format of the online remote proctored exam is that we do administer 2 50 item sessions separately in the afternoon. Next slide, please. The subjects on the first year law students exam are limited to 3: contracts, criminal law, and torts only. Next slide, please. And the first year law students exam is developed similarly, but not exactly the same way as the bar exam. Question drafting is the same. We do solicit from qualified drafters and law professors over the entire country. There's question editing. There is no pretesting, however, compared to the bar exam, during which for which we do pretesting. And then the questions are banked, and the people who are selecting the edge teams, assigned edge team member would be selecting the questions and editing them for administration. Next question, next slide, please. On to examination grading. So all of our graders, none of them would know the identity of any of the applicants. No personally identifying information is available to our graders. We use code numbers for all of the applicants. They're identified by code numbers only. And then the logistics, we have a return of materials from the test centers. We do download the questions for those applicants who type their answers into the Examplify software. The answers are downloaded to our system. And then there's the assembly of the answers for those that are hard copy, as well as to put together the electronic answer files. The graders are all active California attorneys. We have 6 separate grading groups of up to 16 graders each, plus apprentice graders. The apprentice graders do not grade generally. They are there to learn and to watch. We do, however, it's possible that they might be used if there is something that for some reason the regular graders are not able to continue grading. So each of those grading groups is responsible to grade 1 essay question or the PT question. So they're dedicated to grading only 1 question. They are each supervised by one of our examination development and grading or EDGE team members. Each of the graders they all do their independent pre-grading research. They all independently research the questions and write an answer, so that they're very familiar with all of the issues. They also share each other's answers so that they know, can see everybody's ideas in terms of the issues to be graded. Calibration, we have 3 calibration sessions for every administration of the bar exam. The purpose of calibration is to make sure that all of the graders are grading to the same standard. They're all on the same page, so that such that you don't have a situation where you have one grader who grades too high or too low. And then the scoring of the questions is that there's a maximum of 100 raw points per essay question. The PT is also graded on 100 raw points. However, in the final scoring, the PT score is doubled. So the PT is worth 2 times an essay question. The written session of the bar exam is worth 50% of the score, and the MBE is worth the other 50%. There are 2 phases of grading. There used to be 3, but recently the committee changed that procedure, and now we have 2 phases of grading: first read and second read. Also, the Supreme Court during the pandemic last year, around June or July, I think, lowered the cut score, the passing score, from 1440. That's a scaled score, from 1440 to 1390. So if on first read, the applicant scores 1390, at least 1390 out of 2,000 possible scaled points, they pass the exam on first read. If they score 1350, between 1350 and 1389.99, so between 1350 and 1390, they go there. All of their answers go to second read. And then let's see, first year exam, there are 4 grading groups of 3 graders each. They're led by 1 EDGE team member. There are 2 phases. Similarly, to the bar exam, 2 phases of grading. There's first read and then there's reappraisal, which is done by the EDGE team member. 560 scale points to pass, and between 540 and 559.99, you go to the answers go to reappraisal. Next slide, please. Are there any questions regarding examination development or grading? I don't see any, so thank you.
Great. Well, then I guess it's on to me. Good morning, committee members. I'm James Chang. I'm an attorney with the State Bar's Office of General Counsel, and I'll be providing a presentation today regarding the Testing Accommodations Program and the requirements of the Americans with Disabilities Act. Before we go to the next slide, just a brief preface here. The State Bar is committed to ensuring an equal opportunity for all test takers. The Americans with Disabilities Act requires that the State Bar provide reasonable accommodations to applicants who have disabilities, and the State Bar has a rigorous program in place to ensure that. And so what we'll be discussing today is some of the legal requirements, both in terms of the statutory law and in terms of the case law, and then a brief overview of the State Bar's protocols for how we comply with those laws. So with that, we'll go to the next slide. So Title II of the Americans with Disabilities Act requires that a public entity may not administer a licensing program in a manner that subjects qualified individuals with disabilities to discrimination on the basis of their disability. And California state law also imposes a similar requirement that's found in Government Code Section 12944, which states that it shall be unlawful for a licensing board to fail or refuse to make reasonable accommodations to an individual's mental or physical disability or mental condition. Next slide, please. So the definition of disability under the ADA is a physical or mental impairment that substantially limits one or more major life activities, a record of such an impairment, or being regarded as having such an impairment, that is a perceived disability. And the term disability, according to the federal regulations interpreting the ADA, is interpreted in favor of broad coverage of individuals. And so there is a legal mandate to construe disability broadly and in favor of potential applicants. Next slide, please. So the next component is that the disability must be one that substantially limits a major life activity. And this term, substantially limits, is also construed broadly. It is should be made without regard to the ameliorative effects of other mitigating measures. So if a disabled person already is receiving some type of medical treatment that assists them in coping with the effects of their disability, we are not necessarily to to subtract from the effects of their disability by compensating for the mitigation that they're already receiving. Next slide. Major life activity is defined here again from the Code of Federal Regulations, but it's basically major life functions, self-care, performing manual tasks, seeing, hearing, eating, sleeping, walking, as well as major bodily functions. Next slide, please. So Title III of the Americans with Disabilities Act applies to commercial facilities and private businesses, but there are regulations under Title III that apply specifically to licensing exams. And so although the State Bar as a government entity is subject to Title II of the ADA rather than Title III, some of the more specific regulations in Title III that apply to licensing exams provide additional guidance for how we should be administering our testing accommodations programs. And so under those Title III regulations, an entity offering an examination must assure that the examination is selected and administered so as to best ensure that the applicant with a disability is able to achieve results that accurately reflect the individual's aptitude or achievement level. And so the idea here is to ensure a level playing field. If there's a disabled applicant and by reason of their disability, they first face certain challenges in taking the exam, the accommodations offered should raise them to the point where they're able to have an equal opportunity to show their true ability on that exam as non-disabled applicants. Next slide, please. So the regulations under Title III discuss the reasonable documentation requirements for applicants who make testing accommodation requests. The key here is that the documentation request must be reasonable and limited to the need for the requested testing accommodations. They should be narrowly tailored, and where an applicant has provided documentation of past accommodations in similar test settings, such as in their law school or perhaps in another jurisdiction's bar exam, those should generally be given considerable weight. These requirements here come from a combination of the Code of Federal Regulations, as well as the DOJ's Technical Assistance Manual, which is their interpretive enforcement guidelines. Those are not necessarily those don't necessarily have the force of law the way that the Code of Federal Regulations do, but they are, of course, persuasive in interpreting the law, and we do our best to conform to them. Next slide, please. It's also important to understand the role of qualified professionals when we're evaluating information that's provided by applicants. Qualified professionals are the medical providers who have evaluated the candidate and therefore have firsthand knowledge of the applicant's conditions. Again, according to the Technical Assistance Manual, which is non-binding but persuasive, the DOJ states that the reports from qualified professionals should take precedence over other reviewers who have not personally evaluated the candidate. And so again, that's something that we look to. I just want to emphasize again, the Technical Assistance Manual is not in the Code of Federal Regulations or the statute. It is not binding, but we do look to these sources for guidance in interpreting the law. Next slide, please. So under the Title III guidelines, it requires modifications to the exam to allow a test taker to have an equal opportunity. Some of those modifications may include, for example, changes in the length of time permitted for the completion of the exam, adaptation of the manner in which the exam is given, or other auxiliary aids. And so as it's applied here, usually the kind of most common cases that we see at the state bar are, for example, giving 1.5 or double time to candidates for certain portions of the exam. Adaptation of the manner, oftentimes that means providing applicants with paper exam materials instead of the computer if they have some type of disability related to their visual functions, or other auxiliary aids. And so, for example, a blind applicant would be entitled to, for example, Braille materials. There is an important consideration here, which is that the state bar's legal obligation is to provide these required modifications unless doing so would fundamentally alter the measurement of the skills or knowledge the examination is intended to test, or would result in an undue burden to the agency. And so there is a bit of a balance in terms of what the burden is in providing it. And that's something that we take into account when we're deciding what types of accommodations are reasonable to provide. Next slide, please. So we're going to breeze through a few of the key cases that deal with testing accommodations. And there's a lot of slides here, and so I'll just kind of cover them at a very high level to give you some context as to what the governing law is here. There are 2 Ninth Circuit cases that dealt with the bar exam in particular, and so those are, of course, binding on us and are the clearest source of authority that we look to in interpreting the case law. One of the most important recent cases was Enyart versus the National Conference of Bar Examiners. And this was where an applicant, a blind applicant, was granted a preliminary injunction to use a screen reader software on the MBE portion of the bar exam. The NCBE had tried to offer other types of accommodations, but not the screen reader, which was a newer form of technology. For example, they wanted to provide a live reader where they would actually have a person read the exam to the applicant instead of using this newer technology. And the NCB's argument was that what they had offered was already reasonable. But one of the key holdings, if we can move on to the Next slide, please. So here, the DOJ had actually participated in the case, I think either as an intervener or as an amicus, and on NYART's behalf, and was really holding the NCB to the standard of ensuring that the applicant is placed on the same playing field as other non-disabled applicants. So it's not enough that the NCB offered some tools that addressed the fact that the test taker was blind. What the NCB was required to do was to ensure that whatever accommodations that they were offering her would actually bring her up to the same level as to an equal playing field. And the court had held that the accommodations that NCB was offering were not sufficient to bring her up to that level. And what was important in this case, if we can move on to the next slide, was the consideration of evolving technology in testing accommodations. And so part of the case here that we excerpt is that assistive technology is not frozen in time. So as technology advances, testing accommodations should advance as well. And what was really at issue here in the NYART case was the plaintiff's request for this new screen reader software, which the NCBE said they didn't need to implement because they were already providing things like a live reader. And the plaintiff was able to show that in her case, a live reader, having a person read the exam to her, was not as effective of an accommodation that would give her an equal playing field as having a technology assisted reading. And so, what the court noted was that although it may have been the case that perhaps, 20 years ago, when this screen reading technology didn't exist, a live reader might have been considered sufficient at that time, given that technology has evolved and that there are other technologies available that provide more assistance and better allow the applicant to be brought to an equal playing field, then those changes in technology need to be considered. And so as applied to the state bar, when we're looking at the bar exam and we're also seeing technology evolve that could assist applicants, we need to take that into account in terms of determining what accommodations are appropriate to provide. Next slide, please. So the Elder case is very similar to NYART, and so we can just do that very quickly. Elder was decided about 5 years after NYART, and it also applied with a blind applicant who wanted to use the screen reading software instead of a live reader. In this case, that same applicant had already passed the Maryland bar exam using a live reader, and so the NCBE again wanted to provide only a live reader and not the screen assistive, the JAWS technology, it's called. It's the technology assisted reader. And relying on NYART, the district court held that NCBE was required to actually use this newer technology. So next slide. There are other legal proceedings involving legal exams. And so the most prominent of them is the consent decree involving the Law School Admissions Council and the LSAT, the Law School Admissions Test. And so in 2012, the California Department of Fair Employment and Housing sued LSAC, alleging that they were violating the ADA in terms of the documentation request of applicants and documentation requirements, and also denial of request for reasonable accommodations. The United States Department of Justice intervened in the lawsuit, and this became a national class action. Next slide, please. Ultimately, the LSAC had to settle the case by entering into a consent decree requiring it to pay $8.73 million, as well as to implement numerous reforms. Some of those reforms included stopping flagging of LSAT scores for test takers who had received extended time. And so previously, when they were scoring it, the scorers could actually see who had received extra time and who hadn't. They were required to stop that flagging, and they were also required to essentially implement a new system of accommodations that was streamlined, that required less onerous documentation from applicants, and they were required to adhere to best practices as recommended by a panel of experts. And so essentially, under the consent decree, a panel of psychometricians and doctors was formed, and they were required to adopt those any recommendations from that panel as binding. Next slide, please. So the consent decree has continued to be a very significant requirement for LSAC for the several years afterwards. It would continue to be litigated, and at one point, DFEH moved to have the LSAC held in contempt for insufficiently failing to comply with the consent decree in terms of their record keeping, and also the granting of accommodation requests. That is, that they still were not granting them as much as was envisioned under the consent decree. And so the reason that we discuss the LSAC consent decree is to provide an example of what could go wrong if the State Bar does not sufficiently comply with the disabilities laws. It could expose the State Bar to potential litigation and potential resolutions similar to the ones imposed by LSAC here. And so it's important for the committee in conducting its work and in overseeing the State Bar's testing accommodations function to recognize the potential liability in this area. Next slide, please. We also include here a few other cases, not in the bar exam area, but in other high stakes professional exams, so medical exams, to indicate that although there is very high potential liability in the area of testing accommodations, it is necessarily a very fact-specific inquiry. And the courts are going to treat each of these cases on an individual basis, looking at what happened. And so we have a few examples of some cases involving medical exams where ultimately the medical examiners were not found liable because of particular facts in those cases. And so in this case, Bibber versus National Board of Osteopathic Medical Examiners, an applicant had requested extra time. That applicant did have a history of receiving accommodations in medical school, but had also taken other high stakes exams without accommodations and received average scores. And so in this case, if we go to the next slide, the court found that the applicant's dyslexia did not qualify the applicant as disabled, and in that case, the medical examiners did prevail. Next slide, please. There's another example of a medical test here. This is Black versus National Board of Medical Examiners, and this is involving a medical student with ADHD who ultimately was found to be not entitled to additional time to take a medical examination. And this was based on a fact-specific determination that for this exam and as to her, ADHD was not a qualifying condition. I really want to emphasize here that this is a district court case in Florida, and that what we have seen is that the Ninth Circuit and the district courts in California have are much more favorable toward plaintiffs and those claiming disability than courts in other parts of the country. And so, although we do indicate, although we have highlighted this case here to kind of give you a spectrum of the different cases, we would not necessarily want to go with the holding of this case. It's the state bar's practice generally to consider ADHD a disability in many cases, depending on the documentation and depending on the individual cases, the individual facts of an applicant's case. And so I just want to kind of qualify this a bit, but there is a very broad spectrum when these cases actually get litigated. That's what we're trying to emphasize when we provide this example. Next slide, please. So this is the basic process for the testing accommodations here at the state bar. It involves first, the applicant needs to file a petition that includes documentation and verification of their disability. Then a decision is made on the staff level after a review of the application. That can involve a grant of all of the requested accommodations, a complete denial, or a partial grant. And some of those examples of accommodations that are granted typically would be, for example, extra time, a private or semi-private room, permission to dictate to a typist and allow the typist to provide the answer instead of typing it themselves, special versions of the examination questions, such as in large print or an audio format, or the use of a screen reader or speech recognition software. If the applicant disagrees with the initial denial or partial grant of their application, then they do have additional remedies. They can appeal first to the staff level and then up through the committee process. And so that would first come up through the subcommittee on examinations and then potentially up to the full committee. And then finally, they do have a right to seek review of any decision by the California Supreme Court, which is the final avenue for of seeking review of nearly all state bar decisions. So that concludes my presentation on testing accommodations. I'm happy to answer any questions that the committee may have. Okay, no questions. So I'll turn it over to Tammy for the next part of the program.
Thank you, James.
Thank you, James. Good morning, everyone. I'm Tammy Campbell, Program Manager over Operations and Management. We are responsible for all of the eligibility processes as well as the administration of the examination. We are the ones who process applications for the registrations, for all of the examinations, as well as special admissions programs. Next slide. Under eligibility, as I mentioned, we're covering registration, exam applications, the law office study applications that come in. We also are handling all of the special admissions, such as foreign legal consultants, registered in-house counsel, registered legal aid attorneys, military spouse attorneys, the Pro Hoc Vice program, practical training of law students, out-of-state attorney arbitration counsel, and of course, the newest program that was implemented during the pandemic, which is the provisionally licensed lawyers program. Next slide, please. The legal education qualifications for someone to sit for one of our exams would be having a JD degree from an ABA approved or California accredited law school, having a 4 years of law study from a recognized unaccredited law school, law office study or distance learning program, a foreign educated student who possesses a first degree in law, and an attorney who has been admitted in any other state or country with proper documentation to confirm their admission to their jurisdiction. Next slide, please. Under examination administration, we process all fees that are collected for applications and any other processes that we have within our unit. We secure contracts for all the test facilities. We order all of the exams, including the multi-state bar exam from the National Conference of Bar Examiners. We do all the preparation of all the exam materials and supplies that go to each of the test centers. We coordinate all the events set up at each test center for each exam. We handle all the shipment of all exams and supplies that go to each test center and return to our office. We conduct all proctor training, and we also have our own mailroom in admissions that allows us to process all incoming and outgoing mail. Next slide, please. So moving back to look at a traditional exam for the state of California, each administration of a bar exam, we have anywhere from 10 to 12 facilities, 12 to 16 test centers across those facilities, with 5 to 6 of those being testing accommodation test centers. For February 21, we had 3,530 applicants, with 288 applicants who were granted testing accommodations. And for July of this year, we had 7,931 applicants, with 564 applicants that were granted testing accommodations. Next slide, please. So with the bar exam administration, those examinations are taken on a laptop or written by hand. Security is, of course, our highest importance when we're doing this. This includes not only at the test center level, but as well as the security of the exams themselves. And also make sure that items that are allowed at the test center are that the items allowed at test centers are different during the MBE session compared to the California portion of the exam. So making sure that the items allowed during our session and during the MBE session are verified and making sure that we're not letting anything in that shouldn't be. Next slide, please. After an exam, if there were any possible violations that occurred during an examination, an applicant would receive a Chapter 6 of the admission rules. The Chapter 6 of the admission rules pertains to the conduct of applicants at the examination. Applicants are expected to always conduct themselves professionally at an examination test center, and any conduct that violates the security or administration of an examination may be reported to the State Bar as a Chapter 6 notice of violation of examination rules or policies, and in extreme cases, it may require dismissal from the examination test center. Next slide. Some of the common Chapter 6 violations that are encountered during an exam are possession of a cell phone or any other electronic or digital style device in the exam room. Those right there are an automatic sanction of a 0 for the exam session that it was discovered. Also submitting examination answers that do not comply with examination instructions and rules. Observing someone who is writing, typing, erasing, or marking after the instruction to stop writing and typing is announced, as well as other various reasons, including cheat sheets, notes, petitioning for religious hardware after the final filing deadline, and other areas of violations. Next slide. The Chapter 6 notice of appeals process is once the Chapter 6 notice is received, the staff reviews and makes a determination on whether or not that Chapter 6 should be affirmed and a sanction is imposed. Then there's a special hearing that the applicants have a right to request. After that, if it is for a violation that is entitled to a hearing, that is a hearing that is conducted by the Office of Admission staff. If that hearing's results is something that the applicant decides they want to appeal to the CBE, then the appeal is presented to CBE for their review and decision at that point. And then after the CBE's decision, if it is still not something that the applicant is happy about, then it would be next to the California Supreme Court. Next, please. And this leads us over to moral character. I have nothing else. Is there any other questions? I'm not seeing any hands. Okay, with that, I guess I will turn that over to Tara Clark, Program Manager.
Thank you, Tammy. So good morning, everyone. My name is Tara Clark, and I'm the Program Manager for Moral Character Determinations. I also have David Lane, the Senior Attorney for the unit. He'll be jumping in as needed. Next slide, please. And so this is just a brief overview of what my team looks like. So we'll go through the process in a moment, but so we do have our folks in our Los Angeles office, the pre-processing unit, and they're doing the initial check on the application. You can see the composition of staff. And then I think many of you are familiar with our team in San Francisco, and that's where David and I are housed as well. And then of course, we report to the Committee of Bar Examiners and work closely with you for the administrative reviews, which we'll discuss in a moment. Next slide, please. So positive moral character determination is one of the requirements for admission in California, as well as for many of the special admissions programs that Tammy mentioned. So for example, the multi-jurisdictional practice programs, foreign legal consultants, and the new provisionally licensed lawyers program as well. And so it's required by Business and Profession Code 6060, and then defined by the rules of the State Bar, the admissions rules. And good moral character includes, but is not limited to, qualities of honesty, fairness, candor, trustworthiness, observance of fiduciary responsibility, respect for and obedience to the law, and respect for the rights of others in the judicial process. And you will see these values come up again later in the presentation. Next slide, please. And so essentially the moral character application is a background check. We ask for, the applicant's history. So where they went to school, where they resided, where they've worked, going down the list. And the application is pretty intensive. So we do recommend that students begin the application process and hopefully complete it or submit that application no later than their last year of law study. And part of that is the time it takes for us to also process it. It's a minimum of 6 months. As you can imagine, we do get a large volume, and we did see an increase at least the beginning of this year, we think, due to some of the changes that were discussed earlier, the lowered cut score, the remote exam, and the new provisional licensure program. And next slide, please. And so here's what the processing of the application looks like internally. So again, our folks in Los Angeles, they're doing the initial check and they're looking for the minimal documentation needed. So for example, if the applicant said that they held a driver's license in another jurisdiction, do they actually provide us with that record? Do they provide us with their mother's maiden name versus the married name and so on? And so once that application is considered complete and filed, from there, if there's minimal or no notable information, it could be approved or a positive determination could be rendered at that stage. However, if there's anything that needs to be looked into further, it could be something as minor as a civil case from a car accident, or maybe something from one of the references. It'll come up to our team of investigators in San Francisco. There are 9 investigators and then we have the 2 supervisors who oversee the team. And from there, the investigators will look through the application. It may be that they can approve it without asking additional questions. However, if we do need more information, they may write to the applicant, they may write to a third party. And then based on the internal guidelines, there are certain things that they must refer then up for supervisor or manager review. So it'll come up to one of our 2 supervisors. Again, the same options available to them, possibly approving the application, requesting more information, or forward it out for my review. And once the application gets to me, if we can't clear the application just based on the paper review, this is where the applicant will be invited to an informal conference. So prior to October of 2019, the committee conducted the informal conferences. Now the informal conference is conducted with staff, and the panel includes myself, David, and then one of the 2 supervisors. And later we'll discuss what are the possible outcomes. Next slide, please. And so Amy had mentioned earlier the moral character working group. So the working group was convened in 2019, and they concluded their work in 2020, and all of the final work products were placed on the State Bar's website at the end of July 2020. And so one of the things that they went through is they looked through the process to make sure that it was fair and transparent. There was some information online, but it didn't give a good look into the process. So that was one of the things that the working group really strove for. And just anecdotally, we have received good feedback on the information that is now available online. And so when you look online, you can see one of the links is to the factors in conduct. And so it's important to call out, for the applicants and for staff and the committee, that candor and honesty are of utmost importance in the application itself. So as you may know, in California, there's no active misconduct in and of itself that precludes admission. Some other jurisdictions, if you have a felony conviction, that may preclude it. That's not the case in California. And if there is an active misconduct in the applicant's background, we look for, again, the candor, the honesty, severity of the issue, how long ago it occurred, was it something that was repeated, and then also rehabilitation. And that's an important factor as well, as the Supreme Court has stated. And when you're looking at the right-hand side, the conduct, so when we were going through the process for the moral character working group, there wasn't a lot available that we could find from other jurisdictions where they actually called out what are things that we're looking for. So for example, with the unauthorized practice of law, there isn't a question on the application right now that asks, have you or has it been alleged that you've UPL'd, as we call it. And so what we did is we created paragraphs. So it kind of just describes what it is we're looking for in each instance. So that way, as the applicants are going through the process, also they can look through and see, what it is we're looking for. Next slide, please. And so the other big final work product of the Moral Character Working Group were the Moral Character Guidelines. And so if you haven't already looked at these online, I highly suggest you do. So what it is, it's a PDF that's available, and it's organized by the values that we discussed earlier in the positive moral character or good moral character definition, excuse me. So for example, you see on the left-hand side, you have respect for and obedience to the law. And then we tried to fit in the types of conduct that we see often with each value. Sometimes they can fit into more than one, but so the working group worked to just identify where they felt that it fit the most. And you will see on the left-hand side, it goes all the way down to vehicle code infraction or municipal code violation. Because this essentially is a background check, we're making a note of everything in the applicant's background. They may not be required to disclose something, but if we come across it one way or another, we're going to just note it on our side internally. Okay, next slide, please. And so here are the two remaining values. You have the observance of fiduciary and financial responsibility and respect for the rights of others in the judicial process. And we just like to call out again on the left-hand side, we list bankruptcy, applicants are able to avail themselves of that right under the federal laws. However, so we're looking for that the applicant disclosed it because they're required to disclose it. And then was there any bad conduct in there? For example, are there allegations of fraud or something of that nature? Okay, and next slide. And so this is an example of one of the pages from the guidelines. So when you go to the guidelines online, you can see again the values and then the types of conduct there. If you click on the link, it'll take you to that specific page. And so here, each page is separated into 3 parts. Additional inquiry seldom needed, additional inquiry may be needed, informal conference may be needed. And so this is all predicated on an complete and accurate disclosure. So I think some of you have seen when we get the initial form, let's say, for example, form 2 for a criminal conviction, someone may just say, I was arrested for a DUI. So if that's the case, we're very likely going to ask them for more information, even if it was something that was a bit old, but we just need the full picture initially. So here for this honor code or conduct code violation in law school, you can see if it was an academic dismissal only due to a low GPA, we're really not as concerned about that. However, if it comes to a minor violation, maybe some sort of conduct where the school just issued a written warning, then we may ask a little bit more. We may ask for a narrative about what happened, any supporting documents. And then if it goes to a serious violation, quite often plagiarism or any Title IX actions, something that resulted in a suspension or expulsion even, then it'll likely need an informal conference. And at the bottom of the page, you can see the mitigation, aggravation, and rehabilitation box. So this is the same on every page. And the working group, they went through and just tried to identify factors that would fall into one of these 3 categories. So that way applicants can look through it and see what are other factors that we're considering besides just the actual, in this case, the honor code violation. Next slide, please. And so decisions after an informal conference, and this will hold true as well if an applicant does rise to the level of an administrative review with the committee, but so a positive determination. And any positive determination is valid for 3 years. However, if the applicant has not been admitted by that time, maybe they haven't passed the bar exam yet, they can submit an extension application 30 months into that 36-month approval period. And what it is the extension application is not as intensive. They can answer, nothing new to report if that's true. The fee's about half the cost. And it's just a way to give us an update. We'll look through the new information, but they don't have to rehash their entire history. And then we also have a re-refer for further investigation. So sometimes new information comes up during the informal conference. We find out that the applicant applied to another jurisdiction and they've been denied there, but we weren't aware of that. So then we might write to them and say, we need this information now before a decision can be rendered. Or as you may know, we may refer a matter to the Office of Chief Trial Counsel for their review. Once a case does get to the level of the State Bar Court, which we'll discuss in a moment, the Office of Chief Trial Counsel represents the committee. So we do find their review helpful. And then we also have abeyance. So this is one of the lesser known options, I think, and this is where we essentially press the pause button. We just need the applicant to complete something else before we can render that positive determination. So examples are completing anger management, participating in the lawyer's assistance program for a specified period of time, or so on. So the Office of Chief Trial Counsel, they conduct ethics school or client trust accounting school, and often we do ask applicants to complete those as well. And for a negative determination, so standard denial is for 2 years. Sometimes we do see the 1-year denials. And it's important to note that it's a very small portion of the applicants that are denied a positive moral character determination each year. It's less than 1%. But even so, it's not telling the applicant that they can't come back. It's only for a specified period of time, and say the denial is for 2 years, then they're able to come back 2 years later and show us additional evidence of rehabilitation or candor or whatever the issue was in that application itself. But for those applicants that are denied, there are several avenues of appeal. Let's see, and next slide. So the first one is the Committee of Bar Examiners Administrative Review. And so with that, the subcommittee chair will assign a 2-member panel to review the case, and they're doing a record review. And this may even consist of additional information that wasn't available to us, the staff. So the applicants, when they're requesting administrative review, are able to provide additional documents, additional supporting evidence. And then once the panel makes their recommendation, that is decided on at the next full committee meeting. So we'll be doing that later today in closed session. If the applicant is given an adverse determination also by the committee, then they have the option of appealing to State Bar Court. And the first level in the State Bar Court is the hearing department. And this is where OCTC gets involved, and they represent the Committee of Bar Examiners. From there, the non-prevailing party may also appeal to the review department. So it could be either the committee or the applicant. And then the same holds true for the California Supreme Court. And next slide. And so this is just a very brief current initiatives that we're working on. As you know, AIMS, the Admissions Information Management System, we're always just looking for ways to increase efficiency for the applicants and staff. And then we'll be doing a review of the admissions rules pertinent to moral character just to ensure accuracy, consistency, and clarity. And that is all I have, I believe. Next slide. Okay, and are there any questions? And not seeing or hearing any, I'll turn it over to Natalie. Thank you.
Thank you, Tara. Natalie, you're on mute. Hello. Natalie?
Okay, here we go. Unmuted.
Perfect, thank you.
Okay, sorry about that. Thank you. I'm going to start the slide. Show. Okay, so in the area of educational standards, California has a wide range of law schools compared with other states. Around the country, we have ABA-approved law schools. Graduation from those schools meets the legal requirements to allow people to take the bar exam in the various states across the US. And then in California, we have a number of additional options. The Law Office Study, which is outside of the Ed Standards program, but operated by the Office of Admissions, as well as the registered and unaccredited schools, both classes of which are regulated by the committee. Right now, there are 18 ABA-approved schools in California. There are 16 registered unaccredited schools and 19 accredited schools. Typically, the unaccredited step is the first step when a law school would open in California. Students in those schools must pass the first-year law students exam within 3 administrations of becoming eligible, as Lisa mentioned earlier, in order to claim credit for study to date. The California accredited schools have additional requirements, but also additional public protection safeguards, including maintaining a minimum 5-year pass rate of 40% or more. In terms of law school engagement, we work with the law schools in a number of forums. The first one being the Law School Council, composed of 7 ABA deans or potentially other administrative leaders at those law schools, as well as the Committee on State Bar Accredited and Registered Schools, composed of 5 deans, 3 from accredited law schools, 2 from unaccredited law schools, and 2 CBE selections. Your current CBE members are Paul Kramer, your Ed Standards Chair, as well as Greg Murphy, a nationally recognized expert on accreditation matters. Throughout the year, we communicate with not only deans, but also other key administrators at law schools who choose to sign up with the Law School Deans e-newsletter. We also put on an annual law school assembly, as well as an annual registrar's meeting. Those meetings happen to be held recently, September 28th and 29th. And For the second time, we held them online via Zoom. We found that that increased participation, and we got very good feedback from the schools on that. We use those meetings not only to discuss strategic initiatives, but also to solve day-to-day problems to ensure efficient communication and efficient processing of materials throughout the year.
Hey, Natalie, could you make the slides full screen? I'm actually stuck on a small screen device right now.
Absolutely.
Thanks.
How's that?
Good. Well, wait, no, still we're seeing your full desktop.
Are you?
At least I think oh no, maybe, no, yeah, that's better, I guess, yeah.
You're in presentation mode. So I don't know.
Yeah,
Paul.
Natalie, if you go back to the to your main screen. Under, do you see the thing that's clicked that says use presenter view? Unclick that. On the
It's
right.
on the right
Way
side.
on the right under monitor.
Now try it.
Okay. How's that, Paul?
Perfect. That's right.
Okay, great.
Yeah, that's good, thanks.
Okay, this year, in terms of the current issues in accreditation, the new accredited law school rules will be implemented starting on January 1, 2022, phased in over a multi-month period. They will also be accompanied by additional guidelines, which the committee had started discussing in August and will further discuss today for action. These new accredited rules focus on the new purpose for accreditation, incorporating current best practices in accreditation, and also creating a jointly accredited status for law schools that are not only programmatically accredited by the State Bar, but also institutionally accredited by a regional or a national accreditor. So that's what I have regarding the law schools. Any other questions? Okay, thank you. So that concludes my section, and I believe at this point, this also concludes the orientation.
Thanks, everybody. So Alex, I hand this back to you.
Great, thank you, Amy. Before we take a short break, there's one more item before we move on to the report from the director, and that is approval of the August 2021 Committee of Bar Examiners public meeting minutes. And are there any questions or comments about the meeting minutes before I ask for a motion? I don't see any, so is there a motion for
Yeah,
approval?
this is Robbie. I'll move to approve the minutes. This is Michael. I'll second that.
Thank you. Ms. Wong, can you take a vote?
Sure. Dr. Bolton? Let me unmute Dr. Bolton.
Yes.
Thank you. Judge Brody?
Yes.
Dr. Chow?
Yes.
Mr. Chen?
Yes.
Mr. Efting?
Yes.
Mr. Gongora?
Yes.
Ms. Heisinger?
Yes.
Mr. Iseri?
Yes.
Mr. Kaplan?
Yes.
Mr. Kramer?
Yes.
Ms. Peak?
I'll abstain.
Mr. Reyes?
Yes.
Judge Toriaba?
Yes.
Mr. Torres?
Yes.
Motion passes.
Thank you, Ms. Wong. So looking at my clock, it's 10:50 a.m. Let's take a 10-minute break and return at 11, and we will start with a report from the director. Thank you, everyone.
Thank you.
Let's see, people are starting to file back in. Give it another minute.
I don't mean to bring up a sore subject, but how about them Dodgers? Knowing that a lot of you are from the Bay Area.
Yeah, I don't know who you're referring to, David, but maybe half you're making happy and maybe the rest you're not making any friends, but I don't know.
Ouch, David.
No comment.
Well, I mean, look, as I told a friend of mine this morning, it wasn't the Dodgers call, it was the line judge. And it was a bad call, but
I think it was karma for the bad call
That
before
can go
and all the
both
bad
ways.
pitching strike calls and the umpire kicking the ball when Will Smith was trying to pick it up. There's lots of karma going on.
well, remember a couple of years ago with Houston. So if they beat the Braves and they face Houston, well, that was the cheating moment for Houston. Let's see what happens here.
So Alex, can I give you a quick update? We are in the process of gathering our presenters for this next session. So I just want to give you a quick update.
Great. Thank you, Amy. And when Kim joins us, we're going to take roll call.
I've got a question. I may have to call in using the phone to the closed session. Do I need a participant number for that, or is it just is it an open Zoom meeting?
It's not open, so Paul, you should use the number that's attached to the closed session invitation. There are two.
Right, the meeting number, right?
Yes, it's that meeting number.
But there's no participant code to go along with it.
No, that's incorporated in the invitation. So just you need the meeting ID.
Yeah, okay. Right now I'm stuck using my cell phone data for the Zoom, so I want to conserve some of that.
Okay, welcome back, everyone. Ms. Wong, would you please take roll call?
Sure. Dr. Bolton,
Here.
Dr. Cow,
Here.
Judge Brody,
Here.
Mr. Chen,
Here.
Mr. Efting,
Present.
Mr. Gongora,
Present.
Ms. Heisinger,
Here.
Mr. Iseri,
Here.
Mr. Kaplan,
Here.
Ms. Kramer,
Here.
Ms. Peak,
Present.
Mr. Reyes,
Here.
Judge Toriaba,
Here.
and Mr. Torres.
Present.
We have a quorum, Mr. Chair.
Great, thank you. And I didn't say it earlier, but I want to say thank you to all the presenters on that orientation. It was a lot of detailed information. And even though we didn't have a large number of questions, I'm sure they are all open. If you do have any questions going forward, to definitely reach out to them. But now I would like to turn it over for a report from the director, Ms. Nunez.
Wonderful, thank you, Alex. We're going to, we have presenters from ExamSoft, so we're going to jump ahead on the agenda under my report to the July 2021 California bar exam. So let me share my screen. I have one PowerPoint. I will be handing this over to Audrey, and we have members from ExamSoft who will be also in attendance. So with that, Audrey.
Hello again, everyone. I will give a brief recap of where we are with the July California bar examination, and then introduce our speakers from ExamSoft. You'll remember at our last meeting, you asked if they could come to this meeting for some Q&A about the July bar exam. So the last time we met, we talked about what we knew at the time, which was the technical glitch reported by ExamSoft that caused examinees' screens to freeze, and they had to restart to get back into the exam. So since that time, we've done more of our investigation. You'll remember last time we also were asking our applicants to write into us through the admissions information management system. We've read through all of those submissions to us. We've also had various reports from ExamSoft on applicant experience, including all of their case logs from the July bar exam that we also read through. So we've been able to marry a variety of different reports into us with our own applicant experience investigation and come to some conclusions. Just to recap overall, we had the exam on July 27th and 28th. The total number of attendees after we had some partial attendees or no-shows was 7,931 applicants. Of those, 7,742 took the exam remotely, meaning they were using the ExamSoft software for their answers and for the Exam ID exam monitor, which is the video proctoring. So that is the vast majority of applicants, about 189 of them. Again, during the first day of testing, we had reports from ExamSoft that applicants across jurisdictions were experiencing the screen freeze and that they needed to restart their computers to get back into their exam session. That, can you mute Dr. Bolton, please, Kim? The ExamSoft reported, and we reported this back at our last meeting, that the issue was high memory utilization. So the way that the software works to render the image in order to have the answer displayed in your answer window in conjunction with the video proctoring to record an applicant while they're taking the exam. In some applicants' devices that caused a high memory utilization, and everything sort of stopped, everything ceased rendering, and that's why they had to restart. So in our investigation, 31% of our test takers had an experience where they had to restart their computer during an exam session and get back into the session and continue testing. And for those folks, they didn't lose time or content. They were able to restart and get back into their session. The vast majority of them were able to get right back in without losing time or content. So for 158 of our applicants, they required more assistance at the time where they had the event where they had to restart the computer. Their exam session might have submitted, and then they might have needed to contact ExamSoft and get another download of that session to get back in to be able to have their time. So we have different buckets of affected applicants and working with our psychometrician now to figure out grading resolutions if need be, or administrative solutions. And that's where we are after what we reported last time. And I am going to see now who is has been promoted from ExamSoft, so I can introduce them as well. I know I see Britt Nichols, Sebastian Voss. We also should have Kristen Chittenden and Cindy Neagle. Hopefully they are all here. And
we have Mike Mitrione as well, Audrey.
Okay, we do. I didn't see. Okay, so also Mike Mitrione from ExamSoft. So I don't know, Britt, if you want to start us off or introduce the team, and then we can open for Q&A.
Sure, I'm the Senior Vice President at ExamSoft and primarily responsible for the relationship between organizations and clients, and as well as applicants and students. And Mike Mitrione is our Chief Technical Officer, and Sebastian Voss is our Chief Executive Officer. I think Cindy and Kristen are just observing, so.
So I don't know if any of the committee members have their questions ready, or if there's any, do you need to say anything overall, Britt, before we have some Q&A?
I mean, we go on.
Go ahead, Sebastian.
No, I mean, look, we're happy to do whatever the board prefers. If they would prefer just to ask questions and not waste time on a preamble or cover information that you may have already covered with them, we're really looking, we just want to be here and to support you guys and answer questions that come on. I'm happy to do a preamble if that makes sense, but I think you probably have covered it. You did a very nice job in the beginning. And I think you've probably covered a lot of the details that I would cover anyway. So I think unless the board would like something different, I think we'll defer to answer, try to respond to questions. If not, I will speak.
Well, I'll ask the first question. It may be a little bit, probably not in the right order, but I know many members as well as the public are very interested in basically like the next steps to ensure, the next time the test is being administered, what is sort of from ExamSoft's point of view, like what they're doing in terms of next steps.
Got it. So that's a good question. Excuse me. And I'll look to Britt or Mike to help supplement the answer. Basically, shortly after the exam, we did identify what the problem was, as Audrey mentioned, with the memory usage and how the rendering went. We were able to replicate that, and we have solved that technical problem. We have put a release into play now, and that is now being tested. So from a short, like if you go from a tactical point of view, what we've done is we've identified the software problem and we've fixed it, and that's now in production being used by clients. Over the long, like the more strategic question is what we're doing to change our QA processes to make sure that we don't, that we try to catch these things sooner and not sort of after the event, but prior to the event. And looking through what we're trying to do is we've updated our processes. We are trying to do a better job of simulating the bar experience with the multiple starts and restarts, which is different from some of our academic starts, how our academic clients use it, which are not typically 4 or 5 or 6 exams a day. As well as when we did the original work, we didn't see this. So we're trying to get more usage of the software prior to the exam. So we had several 100,000 uploads on that version of the software and did not see the problem, and trying to extend that window to make sure we have more time, as well as changing our QA processes. I don't know, Britt or Mike, if there's anything else you would like to add.
Yeah, Sebastian, I think you covered it. One of the things that, we're doing besides, I think Sebastian added, changing our QA processes to try to simulate more real world bar experiences. Today, we do utilize a third party that helps us get mass testing. We've traditionally done that in a smaller set of tests in terms of duration. We are now adding longer durations to that as well. And as Sebastian also said, making sure that the software we have, we're hoping goes through a midterm and a finals. So it's got a lot of use before being utilized by the bar. And then we have some internal processes in terms of memory analysis and other tools that we've now purchased and implemented as part of our ongoing process to make sure that we're not having any memory issues going forward.
I have a question. During the public comment this morning, one participant talked about the long period of time that it took her to get online with someone from ExamSoft. What accounts for that kind of time frame?
I'll try to start that, Britt, and then leave it to you. Maybe I can't speak about the specifics of an individual. in general? I mean, I don't know, Brett, is there something?
Look, we try very hard to target a very quick and prompt response time. However, when extreme event occurs, it sometimes is not as easy to be able to navigate every individual who's having a problem around the country at that particular given time, to be able to expedite that process. And so sometimes, while the process may be short for a lot of period of time, there may be a moment in time where that balloons while we try to figure out how we solve that particular problem for a variety of individuals that might be experiencing it. And so that would probably account for why that individual might have had that long period of hold time. We have significantly increased our staff from October of last year to January to this July from a support perspective, to try to make sure we're always targeting very short response times. I think you saw in February that was, for the most part, the case. However, because this incident did impact a larger than expected portion of individuals, there were times where their hold times were longer than anyone would like to see them. And we worked through them as quickly as possible to get them back down to a reasonable time period.
Hello, I'm curious to know, these same issues that happened in our jurisdiction, did it happen in similar other jurisdictions? Is this an incident isolated to our examination, or was this a national issue?
This occurred across all jurisdictions.
And are your remedies similar for all other jurisdictions as well, to help the examinees move on from this process, as like you said, trying to move forward with a solution?
Yes, we are consistent with how we are approaching everybody who's been impacted, both from a jurisdiction and then certainly on the calls that we took on the day and after the exam days.
I have a question. Have you already determined what percentages of issues are a result of something in exam software's jurisdiction of control, and what type of problems emanate from an individual test taker?
We have taken that data and we've shared it all with Audrey and her team. So I would look to her to share that data with you. I thought she may have already, but we've shared all that data and been working with Audrey and her team to make sure that we could provide all the data they needed so they can move forward.
Yeah, I'm sure she has. I just have to, go back and review that. Wasn't right at the, tip of my tongue. But
Understood.
in those cases where it's either an ExamSoft issue or a test taker issue, I'm sure you've done this, but maybe you can explain a little bit. Are these categorized into specific types of issues so that you can kind of rapidly get some resolution for these?
Yes, I would say the answer to that is yes, and we've shared that information again with Audrey and her team so that she can the team can appropriately adjudicate how they want to move forward with that particular information.
Okay, thank you.
So you said that you experienced a larger than anticipated flood of problems, if you will. What kind of, in percentages, nationwide, what kind of percentages did you have?
I think the question, if I rephrase the question is, was this the same as it was throughout other jurisdictions? The answer is yes. And I think the numbers that Audrey supplied were very accurate in terms of what we experienced in California. And it was very similar. Wow. So as you can imagine, if a person has to restart their computer and they're concerned, they might call in. And so we obviously have to direct them how to restart their computer. And if that happens, if that happens to 400 people all at the exact same moment, then that might cause the phone line to be backed up for that particular moment. Once we work through those 400 calls and people are in their testing and they know what to do, then that typically doesn't occur again.
So how would you categorize your success rate then?
I don't understand that question.
Of all of the people that took tests in the whole country, what percentage of them experienced problems?
Well, I think what the information that we provided Audrey is accurate. And I think what she has shared is correct. And I think we've answered that question.
So if I understand the question, if I just say for a minute, if you take the same percentages of California, I can't do the math, sorry, quick enough in my head, but 7,700 and change took the exam remotely, and 158 had more serious problems and a restart didn't start. Those are the folks that were impacted. That's that percentage-ish.
So
Am I thinking of that correctly? Sorry, thank you, Donna.
yeah, this is Donna. So I did want to clarify because our definition, California's definition of people who are impacted may be slightly different than ExamSoft. And so what we had pointed out that there were 158 that we can tell lost time or content. But overall, so that's a very small percentage. 99% of the applicants for each essay question experience no problem if you sort of break it down question by question. However, 31% of all of our remote test takers did have some problem. The vast majority were they got the black screen and they had to restart. And although, as far as we can tell, they didn't lose time or content, that's still certainly a very upsetting experience for somebody who is taking something, as high stakes as the bar exam. And so, we consider, all of those people, we don't want to dismiss those people who got the black screen one time, two times, three times as not having been impacted. So we certainly want to sort of distinguish that. But as far as we can tell, like Sebastian said, 158 individuals actually lost time or content as they were proceeding through the exam.
And just to quickly get back to Vince, your question, that 30% or 31% of our remote applicants, it was not user error, right? The restart event was not anything on the user or the applicant end. Sorry, go ahead.
Thanks, Audrey.
So maybe you've answered this before, and if you have, I apologize. Was there something about a particular computer or internet service or something why some people had a problem and some didn't?
So no, maybe I should leave it for the technical guy to say why 31% versus 50% or 20%. Why some people had it and didn't. But it was not, I don't think, specific to a type of machine. But Mike, I don't know if there's something more you can say there.
Sure. So since it was a memory usage issue, so a machine with more memory would be more likely to last longer. We also have a standing policy that if you reboot between exams, that would have cleared up any rendering issue for them in between each session. So those would be kind of two big variables that could have impacted why some experienced it and others didn't.
So this was a problem of memory being allocated and then not released by the software?
Yeah, it was a contention by two processes, both trying to write memory and essentially not freeing it up in time before the next exam started.
So when we go back to in-person exams, one of the processes probably won't be used anymore, right? The monitoring.
Well, the solution was to strip out and separate those two processes. So even remote exams won't experience it anymore. So each process now would be running in its own memory space and has adequate memory so there's no more contention between the two, sub-functions that we're trying to work. And that contention has been removed.
And I understand that the the sort of testing, at the testing stage, the user is warned if their machine is.
I'm sorry. I'm having.
It's very hard to hear you, I think, is what we're trying to say. I'm sorry, if you can speak either into a mic or a little louder, that would be appreciated.
Okay, is this better?
That's much better. Thank you very much.
Okay, yeah, I'm sort of compromised because the place I'm at, the internet went down. What was I going to ask? So in the setup phase, the pre-qualification of their machines, they are told when they are either their memory or some other resources are either too low or right at the borderline, but yet they are allowed to continue. That's a policy decision that's made, I guess. Do you think we should perhaps change that and just tell them, no, you can't take the test if they don't have the qualifying resources?
So, Mr. Kramer, I would answer that two ways. One, there's a yes, if we feel that the portion of the MSR is truly below standard, we do stop them from taking the exam. If it is close, we don't stop them, and in some cases don't tell them that it's close, because our MSRs are really at a point where we can support their device. And so we only stop it when it's below those MSRs. In terms of this memory, having more memory or fewer, so long as it was above the minimum, we would allow them and expect them to be successful taking the exam.
So can we clarify one quick thing? So related to the minimum system requirements. So applicants were told what the minimum system requirements were for this exam cycle. They were also notified when their systems did not meet the minimum system requirements. And they nonetheless were able to take the test without, take the exam without having met the minimum system requirements, despite being notified of that fact. But also the people that were impacted and minimum system requirements didn't really correlate. So people even who met the minimum system requirements experienced this. So I just want to be clear on what happened this past exam cycle.
Correct.
That is correct, Amy. The again, so our minimum system requirements is like 2 meg of memory, which no machines are sold with less than that nowadays. And it would have impacted someone with 4 meg as well. So someone who was well above the minimum system requirements would eventually run into the issue that we had.
So I have a follow-up question. I apologize if it's been addressed. I was at a hearing at 11 o'clock and I just concluded around 11:20. I'm more of the tech-oriented person. So I was just curious about whether if it's specifically a RAM issue or if it's also includes the cache for hard drive writing. The reason I may have to ask the tech person. I think you alluded to that for that particular question, but I was curious if another issue we had was the minimum hard drive space that's required for writing audio and video during the exam. So I wasn't sure if it's specifically the when I checked online and what you verified right now, whether if it's the 4 RAM bare minimum or the required 8 RAM, or rather it may also include, since it sounds like a memory leakage, whether it's RAM or hard drive or whatever, or cache, if it was also recording on the hard drive space, because I know there was some potential issues about if you only have 5 or 10 gigs left on the hard drive, whether or not if that could have caused a problem.
Mike, you want to take that?
Sure. So if you had cache set up, again, it would be and it was gig, yes, not meg. I'm sorry, I misstated that earlier. It would support it until you did run out of, whether it's in process memory or hard drive cache. In the end, it's when you ran out of that available memory.
In terms of the desktop, that's so we could record the files. Those are kind of two different processes. So one is so there's enough hard disk space so it can save off the exam file, but also save off the monitoring file. So if there's not enough space for that, then we don't want to let that start. Versus the memory issue that we would need to actually run the software program. Those are sort of two different issues. I want to make sure we address them both.
No, thank you for that. For this particular instance, will that have really, I'm just trying to isolate the main problem, whether if it's RAM or it could have also been, or just by itself even, the hard drive space cache memory.
Yes, and it would have been both when it ran out of both combined.
Got it. Thank you so much.
By the way, just to give you the math, 158 out of 7,700 is 2%.
So I guess a follow-up is for the potential solution, and I listened half while I was attending my hearing and waiting to be called upon the judge. I believe you are looking at both the RAM issue as well as a hard drive cache, and I'm hoping that through testing and evaluation that we can probably update the specs to say, for example, to improve the hard drive spacing if needed. So even if we had a similar issue in the future, at least it could be addressed enough that it may not be a problem. Because I'm looking at when it comes down to it, I think it's, as you stated, it's the memory leakage or recording leakage that resulted in the issues we had. So I guess, will you be looking into updating the minimum requirements then for computers and laptops?
So the fix was to address the memory leakage issue. I don't think there is any need to update the MSRs. I think that would prevent some people from taking the bar exam. And so we want to make sure that our minimum system requirements are truly equitable for people who have lower end machines, because we know what we need to run our software. So the true fix is fixing the memory issue. That's what we have performed. And I would hate to force people to go out and buy higher end machines that really aren't required.
Definitely, thank you for that.
Do the MSRs account for the possibility that a test taker might be given an accommodation where they are going to take, say, 2 or even 3 times the normal amount of time to take the test?
Yes, Mr. Kramer, they would support, our software should support any number of times taking an exam. Again,
So
this was a memory issue that, was time dependent, that we have fixed and put processes in place to prevent going forward.
Okay, but to be clear, I'm saying when you calculate, say, the amount of hard disk space that is necessary to measure, it would be a different number minimum for somebody who's taking a 1-hour exam versus somebody who's taking a 3-hour exam, correct?
Yes, sir.
Okay, good, thanks.
Hey, Mike, this is Alex. So for
Hi,
the last 3 administrations, technical problems and memory glitches again plague our bar examinees. And as you know, test takers reported being shut out of the exam, having a computer suddenly crashed and facing blank screens. People were angry. I want you to really understand that. That anger continues for the last 3 administrations. And someone has to do something about these problems. Now, clearly these glitches and memory usage isn't new to us, right? This has happened for the last administrations. And so what is ExamSoft doing in the back end that is causing these recurring issues? And is there any way you can give us confidence that issues of this type really won't happen again. Now, I do want to address one issue that you raised, or one potential solution that you talked about, Mike, which is, perhaps you might want to raise the minimum requirements for memory and hard drive space so that you have enough buffer to prevent those closed cases, right? You talked about those closed cases. Let's just find ways to make sure they're not closed cases. And then there are cases where, technical glitches happen, not because of memory or hard drive space, but it's because of some other reasons. And so what solutions do you have in mind for those cases? So it's really a two-part question. One, again, is what is ExamSoft doing on the back end that is continuing to cause these issues? And second question is, what solution do you have in mind for those cases that have nothing to do with memory usage or hard drive space for that matter?
Well, go on.
Go ahead, Sebastian. No, I'll let you start.
So, I mean, I would think, look, I think a couple things. First, I take a little bit of, we did not have serious problems in February, so I do take exception with that. Your point is well taken, and that's why we are constantly trying to do, make continuous improvement in our software to try to make it a better test taking experience. We had, we are always looking at how we write the software and making sure we're doing it at the best possible way. We adjust our QA processes to make sure that we are trying to catch as many issues and bugs as they come up. We do, as Mike stated earlier, we've added more tooling into our QA process around the memory side to make sure that issue goes away. Some of the things that, what we do is really very difficult, and I'm not making excuses, right? We understand the anger, we understand the pressure that the exam taker, the applicants are under. I mean, we've been doing this for 23 years. It's not this is not the first time as a company that we've given the bar. What we do understand is that pressure, and what we're looking at is trying to always try to make ourselves accountable and try to push the software forward so it best serves our exam taker and as well as you guys as the exam administrator in the best possible way. What are we like? It's very hard for us to say it's going to be perfect every time. We don't control the environment. It's the student's machine. So the only thing we can do is to make it perfectly perfect is to force them into a test center or something like that, which is not going to be a good experience for the exam taker. It's actually going to be worse. And so we can raise the standards of the MSRs if that is something that the board desires, but then that may lead to other bias issues where students at lower income or a challenge will have to go out and buy new computers just to take the exam versus the ones that they could use in college or what they're using now. And so we're trying to walk, I guess, along a very slim edge or something, just trying to get it right. I don't know, Mike, if there's anything you want to add.
First of all, Alex, I always, our software is complex to do what we do, but I always am considering as if my children were taking the exam. I understand the impact when something goes wrong, and we do everything we can to, adapt to the constantly changing environment, upgrade the software to meet customers' new requirements. We have to continually improve, and in this stage for the bar, I think one of the best things to do is just to make sure we don't use the latest release to support the bar exam. Something that's been out in the field for 4 to 6 months, I think, is a better answer. And we've got to be able to work with the jurisdictions to acknowledge any issues that might be in that version, but just to make sure we know it's at least going to support the exam, I think is the best answer as we continue to, work together to improve the process for everyone.
I appreciate your comments, Sebastian, and also Mike. And I'm not disagreeing with you in terms of how you're walking a fine line between making sure that people who can afford a computer don't have to go through the necessity to have to buy a new computer. At the same time, I wanted to start thinking about what ExamSoft can do to reduce the amount of memory that would be required to execute the application, or better yet, anything you can do to reduce the amount of hard drive space, right? That way, you're not getting anywhere near, that fine line, right? You're still staying below that fine line. So I just want to make sure that maybe the effort and the goal and overall objective should be to focus on that, right? Then you can solve a lot of the issues without having to think about what's going to happen in later administration, right? So I just want to have some kind of discussion so that we are clear that something must be done about these issues.
100%, Alex. We are never, we're not never happy with the status quo, as Mike has said. We are always working on trying to make the software better. And sometimes those are visible ways and sometimes they're invisible ways. The way we handle compression so we can use hard disk space, how we handle the video or the audio files. So it's, again, using less hard disk space or less processor so the machine can actually function more efficiently. We are always trying to stay ahead with the technology so we can continue to provide the service that the jurisdiction expects, right? Which is they want to get the ability to give a secure exam that is functional. And so it's a bit of a Cold War is one of the ways we talk about it, because there's always new ways that applicants are trying to figure out how to cheat the software. So we have to add that. There's new tools that we can put in the software to actually help it be more efficient and more effective. And we are constantly working on that. And that's what part of Mike's team are working on every day. I don't know how else to answer your question, Alex. I'm sorry.
To follow up on Alex's excellent point, I not essentially agreeing or disagreeing at any point, but he brought up, and others have as well. I'm just looking at the ExamSoft's MSRs for hard drive space, and it states 4 gigs available. I then checked at my law school at UC Irvine School of Law, and they, on their website, saying 1 gig of space. So I think there's a conflict there that they need to update that. But I have an issue about, is a way just to increase or even monitor the minimum hard drive space, because I know it's cache memory, so it's temporarily, but I do know a lot of law students who definitely have more than, say, 60 gigs of hard drive space on the laptops at this point in juncture. And it's something in which I think it needs to be enforced either at ExamSoft level of just, if we were to continue doing video and audio recording such, I think to prevent another potential memory leakage in terms of the hard drive recording, I think that minimum system requirements should be raised up from 4 gigs, because it sounds like if you're recording a lot of audio and other statistics as well with video, I'm not too amazing in terms of recording and all that stuff, and I don't know how much it records per hour, but post session, which is an hour and all. I guess to wrap things up for this, because I'm just rambling right now, I think the minimum system requirements should be raised up from 4 gigs at the least to prevent another similar circumstance of memory leakage, and to find a means, I guess, at the monitoring level or at the first instance of checking up, if there's any way to state or notify that, the minimum requirements of hard drive space needs to be freed up. Again, the only reason I'm bringing this up is I know a lot of people are terrible at hard drive space management, and that's something that I just don't know how it can be enforced at all. And like I said, when I even check at UC Fine School of Law's website of ExamSoft and how they use it, they're extending 1 gigs of hard drive space, which I think might, I'm not sure if there was any initiative on ExamSoft or if it's just say my law school and other law schools initiatives, but I'm getting conflicting messages of how much hard drive space should be needed. In addition to that, if it's whether or not to be increased or not in terms of the minimum system requirements, because like say, if there was, the RAM issue is different. I have no idea how to do the RAM in terms of how the minimum is 4 gigs, requires 8 gigs. Most machines use 8 gigs at the least. Not sure how, but I know that I think this issue, if it is correct, was a hard drive related as well. And I think there just needs a better way of just enforcing, if at all, on ExamSoft's part to make sure the hard drive space is there just in case if there's another similar instance of memory leakage. That way we prevent this what happened with just black screens and people restarting and having to restart the program because the cache was too large or corrupted.
All right, can I interject something here, a little bit out of the weeds? It's all very technical, the stuff about minimum requirements. What I just want to say is if the decision is made to raise minimum requirements, then that's a policy decision that the CBE and the bar make, because now you're getting into equity issues. And those need to be fully discussed. It's not about the technology, it's about equity, which is a social policy issue that the bar needs to look at. So I'm just laying it out there saying,
Agreed.
raise the minimum standards, then take a step back and talk about the equity implications of that.
So normally what we would do, if there was any change, is that we would work with Audrey and her team to discuss it, who would bring it to you guys in terms of policy if we felt there was a change. I will say if there's something at the law school sites that don't match what's on our website, that is the law school issue. The website does reflect what is our latest and MSRs. And so I can't really speak to why they would be any different, right? What's on our website is the right answer. But I fully agree with you, Mr. Kaplan, that we will, any change to the MSRs, we always run those through and talk those through. And if we have a recommendation versus what's actually need to be done, as Mike said earlier, we make sure we clear that all through our contacts on the California bar side, and then we wait back and to hear from them.
Thank you, Sebastian. And thank you, Mike and Britt. Time management right now for us, we're going to have to wrap up this portion of the agenda. I really appreciate the CBE members for your good questions, and thank you to ExamSoft for coming to the meeting today.
Okay, thank you very much.
So, Amy, are you going to continue with your additional items on the report?
Sure. Give me 1 second. I am going to send my PowerPoint onto the screen. Give me 1 second here. So this next item is related to the key statistical indicators. One second. So I do this for each of our meetings, and am I sharing my screen at the moment?
We don't see it right now, Amy.
Okay, I'm sorry. It's I'm challenged by needing to share my PowerPoint. Can I send this over to you, Audrey, to open up for me? Sorry about that.
No problem.
Herbie.
Just need one quick minute. All right, so that PowerPoint is going to Audrey in 1 second. And so in my portion of the reports, I usually report back on the key statistical indicators, which are coming up. For this reporting period, I'm reporting for the month of August 2021. Just to remind everybody, our key statistical indicators report the number of applications received by our office to date, along with last year's count. What I do is I highlight anything in this reporting period, so comparing August 2021 to the previous year, and I report on anything that's experienced a 15% change compared to the previous year. And so as Audrey opens that up, the one item that I can report on, which has been consistent from one meeting to the next, is the number of applicants placed on the motion. So at the last meeting, I reported that there were 68% more applicants compared to the prior year, and we're still at the same statistic. And the reason for that is, as you may recall, in 2020, the July bar exam was postponed to October, which meant that results release did not happen in 2020. They occurred in January of 2021 for that bar exam. So that applicants were, that would have been sworn in and placed on the motion in 2020 happened in 2021. So for that reason, that is the one statistic that is consistent. We're 68% still of a differential in terms of the number of applicants placed on the motion in 2021 compared to 2020. The next item that has a differential is the number of registrations received. So the number of registrations for attorneys. So as you may recall, part of the initial process for registering with the California State Bar is when you're going to apply for an exam or any of our applications, you have to register either as an attorney applicant or as a law student applicant. And the Office of Admissions this year, when compared to August of 2020, experienced a 37% decrease in the number of applications on the attorney applicant side. And the same goes for the attorney examination for the California bar exam. When comparing this August to past August, we have 43% less applications compared to 2020. The moral character determination extension applications, we also have a 35% decrease in the number of those applications this August compared to last. For the MJP applications, this is a multi-jurisdictional practice. So this includes military spouse attorneys, registered in-house counsel, as well as, sorry, there's one more. Registered legal aid attorneys. We have 19% less applications this August compared to last August. And the last category of applications that experience like a 15% or more differential compared to last year are the Pro Hoc Vice applications. We have 25% more applications this year compared to last August. Okay, with that, does anybody have any questions? All right, so the next item is related to the schedule for this December 3rd and 4th committee meeting. We're scheduled to have a 2-day meeting in December. And the second day, so Saturday, December 4th, is scheduled for question selection for attorney members of the CBE.
May I ask a question?
Yes.
Is there an idea as to when we will be meeting in person, or is that going to be sometime off?
Well, you know, right now we are following what the board is doing and what other sub entities of the board following their practice, and we're all meeting online. I think we're going to revisit that towards the end of the year to look for the potential to possibly meet in person in 2022, contingent on the public health status at that point. Yeah, thanks, David. All right, so the next items are updates on state Office of Admissions and state bar activities. And I'm going to provide an update on the provisional licensure program. Audrey, do you mind going to the next screen? So I want to highlight here the number of applications. So I want to be clear that this is the number of applications that we've received for the PLL program. This is our provisional licensing program. And as you may recall, there are two separate tracks that two separate criteria that people could qualify for this program. First are those that are graduates of law schools, JD and LLMs. Anybody who graduated between December 2019 and December 2020. We have about 1,596 total applications received from applicants that qualify based on a graduating cohort. And the next category is a program expansion. As you may recall, the court expanded the California Rule of Court 9.49.1, and which allows applicants who achieved a score of 1390 and 14 who achieve a cut score reflecting our current cut score for bar exams from July 2015 to February 2020. So we've received a total of 884 applications under this program. So I really want to distinguish here that these are applications and not entirely participants. So can we go to the next screen, Audrey? What I'm reporting on here is the number of people, the number of PLL participants who were licensed as in the expanded category, who are now fully licensed attorneys. We have a total of 254. And at the request of the CBE, I have some information in terms of race, ethnicity, law school type, and gender. So as you can see here, this is our current count of our 254 new licensees that were licensed via the PLL program. This is a breakdown of the race and ethnicity as reported by the applicants. So we have 105 white. I'm going to highlight the largest categories: 49 Asian and 38 Hispanic, Latino, or Spanish. All right, can we go to the next screen? And in terms of gender, we have 143 female, 104 male. We do have some non-response and one transgender gender variant. Lastly, we have the school types. And one thing I want to distinguish here is we have the majority coming from California ABA law schools, followed by CBE accredited, and other would include those applicants that are either attorneys coming in from other jurisdictions, and this includes attorneys from from the United States, as well as foreign attorneys, which is why law school is not represented there. And with that, are there any questions about the provisional licensure program?
I do.
Okay.
I have a question. With respect to that and the recent changes that have been made by the Justice Supreme Court. Do we have a significant jump in or significant increase in the number of Latinos, Blacks, and Asians in the bar? And if so, what are the current statistics? Because I know that the Latinos were firmly at around 4%, the Blacks at 2% prior to the COVID. I'm wondering where we are right now.
David, we have not conducted that level of analysis. I know that we do an annual survey of licensees. And I think when that time comes, perhaps we can conduct that level of analysis that is comparing those statistics to those that to the ones that we have related to provisional licensing.
Okay. I think that something like that would be important for us at least to have an idea of where we are, if there's any equity, if we're moving towards any equity at all.
Yeah, I'll make note of that.
Yeah, and we will be publishing our report card on diversity in the legal profession. Probably we were aiming for this quarter, but it may be just shortly after the start of the new year, based on the information that was collected from attorneys during last year's fee statement process when they were paying their fees. And so that'll be updated in early January, like in all likelihood. And then again, as Amy said, we are continuing to survey attorneys on their demographic information, and we'll be able to update that. And what you'll see with the new report card on the diversity of the profession, when it comes out, we've actually utilized a tool to make it more robust and more user-friendly, such that we are not just pulling statistics that we think people would like to see, but rather we are also providing the ability for many of the charts for you to slice and dice the data in different ways on the website to give us greater insight to some of the questions that we might have on the legal profession. And David, absolutely, one of the things that we do look at is the new admittees to the bar and what their percentage of the new admittees is, looking at that in comparison to the overall percentage. And so that is something that we would continue to report on.
All right. Any other questions? Okay. The next item is a Blue Ribbon Commission on the future of the bar exam. And with that, I'm going to hand it over to Alex Chan.
Thanks, Amy. Since the last CBE meeting, the Blue Ribbon Commission has met twice. And during those meetings, we had presentations going over several alternative pathways to licensure. We dug pretty deep into the roots as to the history and all the legal basis for requiring a bar exam. If I remember correctly, we had Judge Alan Chinkman of the Justice of the Appellate Division of the New York Supreme Court speak with us regarding the New York Task Force past considerations and factors underlying their decision to recommend UBE, which has since been adopted. Also, he went through with us some of the task force latest recommendations to the New York Court of Appeals, including one in which New York will use the next 4 to 5 years to develop its own exam. The thought is that New York wants options other than whatever the NCBE chooses to develop, and also the flexibility to create its own relative scoring system. And as to the substance of that new exam, the task force recommends at least one performance test that's based on New York law, also essays to test New York law in all kinds of different emerging areas that are not presently tested by the NCBE, things like health law or immigration or cybersecurity and the like. And while the bar exam will remain to be the primary pathway to practice, the New York Task Force, to my understanding, also favors the development of alternative pathways, which would be developed by a working group that is to be appointed by the New York Court of Appeals. That is, if the court decides to appoint such a group. If I remember correctly, for out-of-state attorneys, the task force wants the option of vouching in as long as the UBE is still being adopted by New York. And under that option, those attorneys would be required to take a course in New York law as a prerequisite for admission, which is very different from California. We also revisited our past by understanding what we did with the last major experimentation on the California bar exam, which was implemented way back. I was barely born, I think back in 1980, by a similar blue ribbon commission. And following that, there were several key research questions that hopefully will be addressed in the short term that will give us more data points on the potential shortcoming of the current bar exam, including whether the performance on a multiple choice test is affected by the amount of time given to answer those questions. The same question for essays, whether performance is impacted by the time allocated, and also to what degree will performance change if the same legal skills tested via PTs were measured by essay or multiple choice exams. In addition to testing, we explored the feasibility of testing clinical skills. For example, would they be administered under the standardized testing conditions, and can they be scored with a high degree of reliability? And all of these really led to the discussion on whether MBE could be eliminated. Would the exam still be fair? Could we still achieve validity, integrity, and reliability with no MBE, right? In other words, what are the potential psychometric impacts of that? We also went through potential alternative CBE configurations, things like having only a written-only part of the exam, or supplement that written portion with new testing methodologies, or with a California developed multiple choice test, right? Everything is on the table. And just last week, we heard from the chair of the Oregon State Bar Board of Examiners, with whom we had a discussion on alternative pathways. One of the options the Oregon State Bar is considering is the potential adoption of a supervised practice pathway, which basically requires an applicant to acquire anywhere between 1,000 to 1,500 hours of legal work under qualified supervising attorneys, which is in many ways very similar to the provisional licensing option that Amy just talked about. And we also went through, or she went through with us, how Oregon attempts to address things like consumer protection concerns to ensure competence of all the applicants. And so with that background, the commission now has broken into subcommittees, or in the process of breaking into subcommittees. One to focus on the pathway to licensure through a licensing exam, and the other subcommittee will explore the pathway to licensure through a non-exam alternative. Each subcommittee, to my understanding, will put all the presentations, the insider knowledge, the know-hows, and the like into formulating what we really hope to be a comprehensive study or recommendation or report that really guide the entire commission on how best to test minimum competence to ensure protection of the public, and to design an exam or exam alternative that is really fair and equitable from the perspective of cost, racial disparity, mode, and also the method of delivery. So with that, I hope I didn't miss anything, but otherwise I will pass the mic back to Amy.
Actually, if I can just
Question.
if I can just add, Alex, so CBE has 2 representatives on the Blue Ribbon Commission, Alex and Esther. And so to make sure that CBE's voice is brought to both of those subcommittees, Alex and Esther divided up. So one of them will be on the exam subcommittee, and one will be on the non-exam alternative subcommittee. And that way they can not just sort of express your voice, but bring back to you the discussion. Those meetings of the subcommittees will also be open public meetings, like the meetings of the full commission. But obviously one of the big tasks that Alex and Esther have there is to share with you what we're hearing, so they can get your perspective that they could bring to the table. And so I really appreciated Alex and Esther sort of dividing up responsibility for the subcommittee, so we could make sure to have full representation from CBE that way.
If I may, Alex, years ago when I was on the Board of Trustees, former Justice, Supreme Court Justice Cruz Reynoso came and spoke to us, but he also discussed his concerns about the bar and the inadequate number of representation by minorities at the time, specifically Blacks and Latinos at the time. And but he also discussed provisional licensing and the test taking that you're talking about. And I'm not sure if he ever wrote anything in that area, but just to let you know, I know that he spoke a lot about this, and he happened to talk to us trustees about it at the time. But I also belong to a committee where we brought in former New York Chief Justice Jonathan Lippman, I recall, and he also had a lot of ideas, and he was the one who brought New York into the UBE at the time. There was a lot of discussion about that. I'm not saying we go into UBE, but he also had a lot of ideas with respect to provisional licensing. So not sure if you went into that area, but just a couple ideas that came to mind when you were speaking. Thanks for that presentation. I really enjoyed it.
Thank you, David. I will keep those in mind.
Question. These subcommittees, Alex, are they going to be just a couple members of the full commission, or you're basically going to take the membership and split it in half and assign them to one or the other?
That's beyond my pay grade. I will defer that question to Donna. I think Donna would know more than I do on that. Donna, you muted.
There we go. Whenever I'm muted, I lose my mouse and I can't unmute. So Paul, it's the latter. We have solicited interest from each of the commission members for which subcommittee they would like to be on. And then the chair will take all of those preferences into account. And to the extent necessary to equalize the size of the subcommittees, may move some folks, but generally wants to adhere to everyone's preferences. And we hope to have a fairly even split on both of the subcommittees. So it'll be the entire commission divided into.
Thanks.
All right, thank you, Alex. Next, we have an update on differential item functioning by Bethany Peak.
Okay, so the DIF working group, we are actually meeting next week on Tuesday, I believe. But in the meantime, what we have been doing is performing, well, we're not performing anything. Ron and the people that do math are actually performing the work, but we broke down and we did subgroups to evaluate potential DIF in bar exam questions. And so to give you guys an idea of the exercise, essentially, Lisa divided us up into teams of 2, and we were each provided with a subset of about like 20 bar exam questions. And then we were given a spreadsheet to identify what potential DIF issues that there might be in those questions. So for example, some of the, obviously like cultural bias was one. So we would review a question, and if we thought there was anything in there that might be, you know, biased depending on your culture, we would just note it. Some of the other topics we addressed were like, is there anything offensive? Is it perpetuating any stereotypes about different groups? Unfair representation. And I thought, for my own personal opinion, I thought the spreadsheet and the categories that we reviewed were pretty inclusive. I like that it wasn't obviously just race and gender, but it was a lot of different topics. So for example, like in my group, one of the things that we had discussed, we had a bar exam question. It was real estate, and they were talking about like a retaining wall. And my partner had noted that, you know, if you were essentially raised poor, a lot of us don't even know what those are. And so that was like the type of thing that we might flag. And so it was good because, you know, there are some questions that were just highly offensive, maybe on gender. And then there were others like the retaining wall, where it's like, this isn't offensive or hurtful, but it possibly could impact some people and their ability to, you know, answer the questions fully. And so Lisa met with everyone, and like I said, she's passing the data on to Ron, and there'll be some analysis, and that is what we will be discussing at our next meeting next week. And so at the next CBE meeting, I'll have a more substantive update.
Great, thank you, Bethany. Anybody have any questions, Bethany? All right. All right, and the next item is a report back on the Law School Assembly and Registrar meeting. And with that, we have Natalie Leonard.
Sure. Thanks, Audrey. Thanks, Amy. So every year we have annual meetings, Law School Assembly and Registrar's Meeting. The Law School Assembly is an opportunity primarily for the deans and other administrators of law schools to talk about state bar initiatives, but also state bar adjacent initiatives, but really focused on the direct concerns of the law schools. So the Law School Assembly this year focused on the most recent bar exam and the conditions for the upcoming bar exam. The Bar Strategies and Stories program results to date. And I know these have been presented in the CBE before, but this was an open forum for the law schools to ask their questions as well. We can also sometimes target presentations. So for example, when there was a discussion of the Blue Ribbon Commission, we were able to bring all of the law school members of that Blue Ribbon Commission to talk about their experience and also to receive questions from the law schools. We took one section of the program to talk about those law school, state bar adjacent programs that I mentioned. So sometimes other organizations create programs that can be helpful to law schools in response to state bar programs. And in this case, we featured two. In the area of data collection, the State Bar has been expanding the data collection available in the area of gender, ethnicity, and eventually veteran status, disability. And as a result, the National LGBTQ+ Bar has expanded the campus climate survey that they offer to ABA law schools now to encompass the unaccredited and accredited law schools as this new baseline gets formed for those schools. So that was very exciting to share. In addition, that organization will be doing their national conference here in Los Angeles in 2022. And the law schools were able to network with that organization to help their students and professors be involved in the presentations in the very large career fair that they have, as well as the Law School Lead Academy. In addition, we also had the California Lawyers Association come to speak in response to the provisional licensure program. That organization has created an opportunity for current law students and recent graduates to join the CLA for free. And once they are members, they can also participate in a forum to help locate assignments for the provisional licensure program, but also to network with other PLP attorneys once they're in the program, and to have a toolkit to share with potential employers who may be thinking about employing PLLs. The registrar's meeting was held on a separate day. In that case, the registrars attend. They may also bring other administrators. And it really was broken into two sections. The first was built around our first opportunity to share the applicant portal from the student perspective with the registrars. We received many questions in advance and had a pretty vigorous discussion during it as well. And so it was very helpful to see the types of questions that law schools were getting, the ways that the applicant portal has improved processing for students, and ways that we can continue to enhance the portal in the future. In the afternoon, we had a special section focused on our unaccredited and accredited law schools, talking about the requirements for the annual compliance report that will be due this fall. The deadline is November 15, and then also about the rollout of the new accredited law school rules that will begin in January. It was a very helpful and successful meeting, primarily in part because of the great work of the CS bars and the Law School Council up front, thinking about the types of topics that would be helpful, and also the questions that the individual participants submitted in advance. So I want to thank everyone who participated and hear from our own CBE. I'd also like to thank Paul Kramer, who was kind enough to attend the special section on the rollout of the new accredited law school rules. It was very helpful to have him as both a member of CS Bars and the Committee of Bar Examiners there to take questions directly. Any questions? Okay, thank you, everyone.
Thank you, Natalie. And we received a lot of positive feedback on both of those events, so thank you. All right, now the last item is recent developments, and we don't have any. So with that, I will hand it back to you, Alex.
Thank you. So looking at the time, it's about 12:20. I think everybody would appreciate a break, that being lunch. And since we have a number of items both in closed and still in open, let's make it a 30-minute break, sort of a working lunch. So let's return back at 12:50. When we return, we're going to go into closed, as was mentioned earlier, because of the availability of a number of our presenters today. We should start in closed session. So all the committee members should have the link. Please go into closed at 12:50. And then for the public, we will update you on when we're going to return to open. Please monitor the website. So with that being said, thank you, everyone, and we'll see you back at 12:50 in closed session. Thank you. Hello, everyone. We're going to pick up where we ended with open session. I'm going to give it a few seconds as I see a few more members coming back into the room here. Okay, I think we're ready. So when we ended, we were just about to begin with the open agenda items related to examinations. First one being the approval of the technical report on the June 2021 first year law students examination. I'll turn that over to Lisa and Michael Cow, Dr. Cow.
I wanted to go over, this is the agenda item 0200, which is the, just like what Alex said, the approval of technical report on the June 2021 first year law students examination. This was prepared by our committee's psychometrician, Dr. Bolus. And the recommendation is that the technical report be approved, received, and filed. Does anyone have any questions? If not, can we get a motion for the to move the technical report on the June 2021 first year law students examination dated August 20th, 2021, which was prepared by Dr. Bolus, be approved and therefore received and filed?
This is Bethany. I'll move.
Can we get a second?
Paul,
Thank you,
Second.
Paul. Kim, can we have a vote?
Second by Mr. Kramer or Mr. Torres?
Kramer.
Thank you. Dr. Bolton? Judge Broden?
Yes.
Dr. Cow?
Yes.
Mr. Chen?
Yes.
Mr. Efting?
Yes.
Mr. Gongora?
Yes.
Ms. Heisinger?
Yes.
Mr. Kramer?
yes.
Ms. Peak?
Yes.
Mr. Reyes?
Yes.
Toriaba? Mr. Torres?
Yes. It's like she's frozen.
Yeah, I think she froze when she was calling me.
Well,
I'm sorry, there's a connection, internet connection, so the motion passes.
I vote yes.
Thank you.
So the next item on the examinations agenda today is the approval for proposal of the 2021-2022 examination goals. So this is agenda item 0201. So I just wanted to highlight that hopefully we can try to have 2 training sessions for this upcoming year. And otherwise, does anyone have any questions? Okay, if not, I'd like to see if we can get a motion that the committee of bar examiners agree with the staff recommendations. The following motion should be made. Move that the report on the 2021-2022 examination subcommittee goals be approved. Do we have a motion?
So moved as stated by Dr. Cal.
Thank you, Mr. Torres. Do we have a second?
I'll second, Vince.
Thank you, Vince.
Dr. Bolton? Dr. Cow?
Yes.
Mr. Chen?
Yes.
Mr. Efting?
Yes.
Mr. Gongora?
Yes.
Ms. Heisinger?
Yes.
Mr. Iseri?
Yes.
Mr. Kaplan?
Yes.
Mr. Kramer? Ms.
Yes.
Ms. Peak?
Yes.
Mr. Reyes?
Yes.
Judge Toriaba? Mr. Torres?
Yes.
The motion passes.
thank you, Ms.
Kim, you skipped me, but I'm a yes.
Oh, I'm sorry, Judge Broden.
Thank you, Ms. Wong. So we're going to go to operations and management report on the June 2021 first year law students exam cost analysis. Ms. Campbell.
So as we're all aware, we're still in the pandemic and we have moved our exam to an online format. That, of course, has changed the way our costs have been allocated for what we do with putting on the exam. The direct cost for administering the June 2021 first year exam was $52,923 for 275 applicants. When you compare this to the June 2020 first year exam, it's $29,108 for 267 applicants. I would like to point out, though, that when we did the June 2020 cost analysis last year, at that time and all analysis prior to that we were doing for the exams, we were only basing it on the cost to put the exam on in person at a test center. So we didn't include anything on the back end. We didn't include costs such as grading, printing, and anything that we paid for exam license fees. So that's something that made the numbers skewed a little bit. So
In the agenda, I've kind of pointed out that this analysis is based on stuff that's itemized in attachment A and does not include state bar personnel, does not include the fact that we have general counsel who works with us, and various other costs that are not included in this cost analysis. Of course, we do have the video review with the online exam, and that takes time from our staff to go through and review flagged videos, determine if there's a violation, determine if it's a Chapter 6 that's going to be affirmed or a sanction. So there's a lot of extra work that's included with the online exam. With regards to the previous example of the previous exam administration financial reports, we also are not including staff that are year-round focused strictly on putting on the exams that we do. So that's another component. And it also doesn't include things such as the AIMS system, which is our admissions information management system that has to be maintained, IT, overhead, including all of our building space. And so all of those factors are not always being included in there. So that's something I wanted to point out. Based on the cost analysis previously reported for June 2020, I did go ahead and add some of those costs back in to kind of show that differentiation there between the two. And those items that were not included before was for the grading and the printing. So when we add the grading and the printing into the June 2020 analysis, it brings that total up to $42,013. So that gives it where you see that it's come a little bit closer. And even though June 21 is still more expensive than June 20, we also had an increase in applicants. The cost for the exam soft ID and monitor was more expensive from what it was in June of 20. And so that just shows you though that we're still kind of in line, being that we had additional costs this time, but with more applicants. The overall cost for the June 2021 can be attributed based on the increased per person fee, the exam ID monitor fee, as well as higher printing fees, because last year COVID prevented us from sending it out like we normally would, and we had to try to do it in-house on our own copying machines. So just a couple more things to point out is usually the larger percentage of our costs is associated with our proctors, our facilities, and our electrical outlets that we provide in person. These costs have now shifted, and we're seeing the larger percentage of our costs are based on administering it online. The other thing to note is for the June 2020 in-person exam, we only had 7 applicants that took the exam at the State Bar offices, and those were both accommodated and extenuating circumstances. And that was only about 2.3% of the total number of applicants and 11% of the total exam cost for that. For June 2021, we ended up with 14 applicants, which was an increase that doubled. And that same thing, accommodated applicants and extenuating circumstances, that now comprise 5% of the population and increased the fees to 13% of the total costs. So with the revised June 2020 total cost there, it's approximately $135 to administer the first year law students to an applicant taking the exam remotely, compared to approximately $394 for each applicant taking the exam in person with testing accommodations and extenuating circumstances. During the June 2021 exam, it cost approximately $166 per applicant to administer the first year online, versus $683 for each applicant taking the exam at the in-person test center. And for the overall cost per applicant, June 2020 was approximately $144, and the June 21 was $192 per applicant. So that is the report on the June 21 first year cost analysis, if anybody has any questions.
And Mr. Epting, I apologize, I skipped over you. I know you're chair of this committee, so I'll let you take over this part.
Thank you, Tammy. So I think the only other agenda item for us is agenda item 0301, which is the goals. Are we going to
I think we need to do a motion.
Sorry, I did motion first. You're right. So,
I have a question, Mr. Chair, before we move forward.
yes.
We had received a comment discussing about the cost. Is that anything in reference to this presentation, Tammy, that we could kind of get a little bit more clarity, please?
So I do know that the public comment, I believe, was looking at the cost difference between an attorney exam fees versus a non-attorney exam fees. We do have that on the O&M goals for next year that we're going to circle back around to do an analysis of all of that and see where everything will land. But I think the cost analysis report that I just provided kind of touches on some of the other things, is that we haven't always included all of the back end costs, I guess I'll say, that are involved with putting on the exams. All of our past cost analysis were focused on what it takes to do it at the facility, and that was it. So that's something that we've changed, of course, in this past year, where we're now presenting with more information, so that way it can be more transparent to see these other costs that we've never reported prior. So that's kind of what I was seeing between that and the public comment.
Awesome, thank you.
You're
That's all my
welcome.
questions. I'll move to adopt the report. Receive and file, I believe, right?
I'll second. That was Dave Torres?
Yes.
Okay.
Yeah, I think it's to approve it, if you look at the screen.
It's cost enough to be approved.
Okay, Kareem, you agree?
Yes, sir.
Kim, can you do roll call?
Yes. Dr. Bolton,
Yes.
Judge Brody, Dr. Cow,
Yes.
Mr. Chen,
Yes.
Mr. Efting,
Yes.
Mr. Gongora,
Yes.
Ms. Heisinger,
Yes.
Mr. Iseri,
Yes.
Mr. Kaplan,
Yes.
Mr. Kramer,
Yes.
Ms. Pick,
Yes.
Mr. Reyes,
Yes.
Judge Toriaba, Mr. Torres,
Yes.
Judge Brody, are you there? The motion passes.
Thank you, Kim. So the next item then, moving on, is item 0301, which is the operation and management goals. As Tammy indicated earlier, one of the things we're going to try to do this year is on the appeals regarding waiver of committees' administrative policies, such as more time to be licensed and such. We're going to ask the committee members to actually give reports, much like we do with moral character and accommodations. The other things we're going to continue to do like we do before, reviewing reports and expenses and that sort of thing. One thing I want to talk to Tammy about is, I guess we're working on a training film for the bar exam. And maybe Tammy, you could report on that a little bit next meeting, just to kind of say where's that coming from, just so we know what to expect when we get that next August.
Okay.
And then again, we're going to be some proposing guidelines for interpretation of administrative admission rules. And as Tammy indicated, we're going to look at fees. So those are the goals. Anybody want to make a motion with respect to the operation and management goals for 21-22?
Move to adopt.
Anthony will second.
Thank you. Who's the second? Bethany?
Bethany.
Okay. Any good discussion? Kim, can you call roll call?
Sure. Dr. Bolton,
Yes.
Judge Brody, Dr. Cow,
Yes.
Mr. Chen,
Yes.
Mr. Efting,
Yes.
Mr. Gongora,
Yes.
Ms. Heisinger,
Yes.
Mr. Iseri,
Yes.
Mr. Kaplan,
Yes.
Mr. Kramer, Ms. Pick, Ms.
Yes.
Pick, Mr. Reyes,
Yes.
Judge Toriaba, Mr. Torres,
Yes.
the motion passes.
Thank you, Mr. Efting. Thank you, Ms. Campbell. Now we're going to move on to educational standards. I'll turn it over to the chair, Mr. Kramer and Ms. Leonard. Mr. Kramer.
Thanks, Alex.
Yeah. First is 0400. Are you hearing me okay?
Yes.
Yes.
Good, good. I've got so many different headphones to choose from here. So first item is 0400, action on a major change for Empire College of Law to extend the option for online teaching. We're going to see a bunch of requests to extend online classes in December. This one is a little different in that Empire, its plan is to return to the classroom teaching in January 2022, but to allow some flexibility for those students and faculty who cannot attend classes in person, they would be allowed to attend via simultaneous video and audio links. So they would be visually and audibly connected to the classroom, but they would be in another location. They'll be encouraging everyone to attend in person, and the bulk of their students and faculty are expected to do so. So this is not an online JD program, and the school recognizes that, and if they choose to try to move to online in the future, they would file a further application for a major change. Any questions? Okay, Natalie, can you put up the motion?
Sure.
Or Audrey? Thanks. So the staff recommendation and my recommendation is to approve their request effective immediately.
I will make that motion. I'm sorry, did you move or? I will second.
No, I'm semi-neutral.
David, you're making the
Oh,
motion.
I'm sorry. I'll move that the proposed motion that we voted on, the proposed motion that the Committee of Bar Examiners receive and file Empire College of Law's request for major change, so to add the option to deliver JD classes simultaneously in person and via video conference as set forth as stated by Mr. Kramer.
This is Bethany. I'll second.
Okay, thanks, Bethany. Kim, take the roll, please. Is she there?
Dr. Bolton? Hello, I apologize for having, hello?
We can hear you.
Oh, okay. Dr. Bolton? Judge Brody? Dr. Cow?
Yes.
Mr. Chen?
Yes.
Mr. Efting?
Yes.
Mr. Gongora?
Yes.
Ms. Heisinger?
Yes.
Mr. Iseri?
Yes.
Mr. Kaplan? Mr. Kramer?
Yes.
Ms. Peak?
Yes.
Mr. Reyes?
Yes.
Judge Toriaba? Mr. Torres?
Yes.
The motion passes.
Could you hear my
Thank you.
yes? I don't know whether I was in or not. Could you hear me?
No, I couldn't hear you, but thank you, Dr. Bolton.
Okay.
Okay, next item is another major change for Pacific Coast University School of Law. The request is to modify the JD program to change from a quarter schedule to a semester schedule. It's a change that PCU implemented in September, but they did not apply for permission before doing so, but staff told them they needed to file a major change request. They've done so. And so this action would be a retroactive approval of that change. Unfortunately, it's not ready for our action today. This morning, Kim notified us and that of a posting of some additional materials that PCU filed on Tuesday and Wednesday of this week, which included a modified curriculum list that conflicts in some regards with the information it originally provided with its application. Filed this late, the staff and committee members are preparing for this meeting. There is insufficient time to properly evaluate the new information. Staff and I recommend that we take no action today and bring the item back in December, provided that PCU answers some continuing questions about giving degree credit for one or more academic support classes, which is an unresolved question at this point. So no action is required, and we will hopefully bring it back in December with a more fleshed out evaluation of the facts. Any questions about that?
Yeah, they have started this semester interval.
Yeah, it's not the approach we approve of or recommend that schools take. One of my purposes in telling you that story today is to send a message to the schools that they need to apply in advance for changes, and with sufficient time so that we can consider them. And if there are any questions that need to be resolved, there's time to resolve those as well before our meeting where we take action.
Thanks, Paul.
Okay, so the next item is 0402, and that's adoption of proposed guidelines regarding accredited law school curriculum requirements, out-of-state services, identification of accrediting agency in space-constrained situations, record-keeping obligations, and reporting requirements for jointly accredited law schools. Following our approval of the new draft rules for accredited law schools last year, the CS Bars Committee worked on new guidelines to accompany those rules, did so from January through June of this year. They were first presented to this committee in August for discussion and to allow time for comment by committee members and the public in case there were any remaining issues to iron out. Originally, the original draft guidelines covered the 5 topics. Natalie, if you want to put those up, that were mentioned in the title of this item on the agenda.
Sure, Paul.
Staff is recommending that 3 of them be adopted and 2 not be adopted. And if there are any questions, Natalie can go into more details about them. On Wednesday, the CS Bars again reviewed them and did not recommend any further changes. And there has been no other public or committee comments received. These guidelines are so much smaller than the previous guidelines, largely due to the revised rules, which incorporate some substantive requirements previously found in the guidelines, and also move away from a prescriptive approach towards performance standards in many areas. As we begin to apply the rules in real life next year, we may find that further clarifications are necessary, and we'll bring back additions and refinements as necessary. An important theme for some of the schools is reducing the reporting requirements for the jointly accredited schools. That especially is somewhere where we need some real world experience to strike the proper balance between their desire for reduced administrative burdens and our continuing need to acquire data to assure that we can enforce our standards and requirements and make sure they are satisfied. So Natalie has the topic areas up there. That's not the one.
Yeah, this is the prior slide. We'll move ahead to that one. Here you go. So these are the 5 that were proposed by CS Bars, adjusted so you can see the 3 that are recommended by staff that were discussed in August. No change to the proposal that was presented in August.
And the proposed recommendation would adopt the staff recommended 3 guideline provisions. Are there any questions or comments? And Natalie, you want to pop up the motion, or is that Audrey?
I'm going to stop sharing and then Audrey will bring up the motion.
Is there a motion from the group?
I move that the Committee of Bar Examiners approves the proposed guidelines for accredited law school rules as set forth in attachment B to become effective January 1st, 2022. Torres.
Second by Brody.
Dr. Bolton,
Yes.
Judge Brody,
Yes.
Dr. Cow,
Yes.
Mr. Chen,
Yes.
Mr. Efting,
Yes.
Mr. Gongora,
Yes.
Ms. Heisinger,
Yes.
Mr. Iseri,
Yes.
Mr. Kaplan,
Yes.
Mr. Kramer,
Yes.
Ms. Peak,
Yes.
Mr. Rios,
Yes.
Judge Toriaba, Mr. Torres,
Yes.
the motion passes.
Okay, thank you. Next is 0403, action on recommendation for updates to the accredited law school fees. With the coming jointly accredited status on the horizon, we need to update our fee schedule to recognize the applications we're likely to receive for that status. And in looking over the schedule, Natalie thought of another few minor clarifications. To be clear, this is not a comprehensive review of the fees, which, if it is to come, would be part of a future effort, perhaps in concert with the review of the bar exam fees. This is just to get ready, basically to get ready for jointly accredited applications and clarify a few other minor things. Natalie, is there anything in particular you would like to highlight?
Just really for those that haven't seen the fee schedule before, the fee schedule structure for the accredited law school rules is briefly as follows. All of the schools pay a very modest annual fee. It's about $2,000 per school. And then beyond that, they are charged a time and charges fee at a set amount hourly charge for the additional services that are required during the year, such as their motions for major changes. And so this is really a technical amendment applying that same formula, charging the time and charges for the application as we do already. So these really are technical amendments rather than any other type of change. And also, while we're at it, in the first column of the fees, it shows the rule that is related to the fee, and we're updating to make to change it to the new rule numbers.
So the appropriate motion would be to recommend that the Board of Trustees adopt these amendments to the fee schedule. Any questions or comments?
This is Robbie Brody. I will make the motion that the Committee of Bar Examiners recommend that the Board of Trustees amend the accredited law school fees as set forth in attachment B.
I'll second the motion. This is Vince.
Thanks, Vince. Kim?
Dr. Bolton,
Yes.
Judge Brody,
Yes.
Dr. Cow,
Yes.
Mr. Chen,
Yes.
Mr. Efting,
Yes.
Mr. Gongora,
Yes.
Ms. Heisinger,
Yes.
Mr. Iseri,
Yes.
Mr. Kaplan,
Yes.
Mr. Kramer,
Yes.
Ms. Peak,
Yes.
Mr. Rios,
Yes.
Mr. Torres. The motion passes.
Thank you. Next is 0404. Report on administrative updates at accredited and unaccredited law schools. This is purely an informational item. No action is required or recommended. Does anyone have any questions about it? Okay, hearing none, I'll move on to my last item, which is 0405, and that is approval of the proposed 2021 to 2022 educational standards goals. Note that this year we'll be implementing the new accredited school rules and guidelines, and we're going to start reviewing the registered unaccredited school rules to see where they might be improved, along with other things. Any questions or comments? Do we have a motion to approve the guidelines or goals?
I'll
Rather?
move to approve the guidelines.
Is that Mr. Torres?
Yes.
Second, Kareem.
It's a motion
you.
to approve the goals, right?
The goals.
Correct.
Dr. Bolton,
Yes.
Judge Brody, Dr. Cow,
Yes.
Mr. Chen,
Yes.
Mr. Efting,
Yes.
Mr. Gongora,
Yes.
Ms. Heisinger,
Yes.
Mr. Isari,
Yes.
Mr. Kaplan,
Yes.
Mr. Kramer,
Yes.
Ms. Pick,
Yes.
Mr. Rios,
Yes.
Mr. Torres.
Yes.
The motion passes.
Okay, that's it for me.
Thank you, Ms. Leonard. Thank you, Mr. Kramer. I believe the final item is moral character. I'm going to turn it over to the chair, Vince Reyes. Mr. Reyes.
All right, this is item 0500. These are the goals for the Moral Character Committee for this coming year, and they look very exciting. We've got a number of trainings that are scheduled, one on bias in determination of moral character, because that was going to be today, but we've withdrawn that. Another on PTSD, which I think is good because this often crosses over with TA or accommodations. We will look at court cases. I assume these are outside court cases or any court cases, Tara, that are relevant to moral character determination, with more topics to come, plus the ongoing admin reviews. And so we have to thank Tara and David for putting this together, as well as Bethany and last year's committee for working on these goals. So I guess we're looking for an approval of this, a motion to approve.
This is Bethany. I will move to approve the moral character goals for this upcoming year.
I'll second.
And thank you. Ms. Kim, can we get a vote?
Sure. Dr. Bolton,
Yes.
Judge Brody, Dr. Cow,
Yes.
Mr. Chen,
Yes.
Mr. Efting,
Yes.
Mr. Gongora,
Yes.
Ms. Heisinger,
Yes.
Mr. Isari,
Yes.
Mr. Kaplan,
Yes.
Mr. Kramer,
Yes.
Ms. Pick,
Yes.
Mr. Rios,
Yes.
Mr. Torres.
Yes.
The motion passes.
Back to you, Alex.
Great. Thank you, Mr. Reyes. Thank you, Ms. Wong. I believe that's it. We are done with today's meeting. I want to thank all the committee members for your commitment and the public who joined us in this late session. So with that, enjoy the rest of your day and have a great weekend. Take care, everyone. Bye-bye.
Everyone.
Bye.
Take care.
Bye.
Thank you.